We can do, let's do a far out date. Because there's no point of adjourning it for a month. I don't think this would be completed in a month. When was the complaint filed, Attorney Phillips?
My understanding, it was filed yesterday.
Okay. August, does August sound? June, July, August. Let's do an August date.
Okay.
And Judge, who is that for? I don't think we called the matter yet.
Okay, let's call it. Calling case number 2334-2450. This is Americold Inc. versus Wendy Houston and occupants on West Parkway.
Morning, Your Honor. Ted Phillips appearing for the defendant, Ms. Houston, P35900, standing in for Attorney Jerome Goldberg.
Good morning, Your Honor. Attorney Joel Bornkamp here on behalf of Americold Incorporated, P85016.
For the record, there's been a quiet title action filed in circuit court. Case number 23-006261-CH. And the parties are asking for an adjournment for that matter to be litigated.
All right.
And Your Honor, for the record, plaintiff's attorney at this point has no objection, as I've not been able to review the pleadings that were filed recently. We spoke with Attorney Phillips off record, and he's going to provide those to me after this. So we would just ask the court for an adjournment to allow the circuit court matter to be addressed.
And the circuit court matter is likely to take 2 to 3 months minimum. What about August? Let's see, August 21st.
I'm sorry, Your Honor, you say August 1st?
August 21st.
August 21st is fine for the plaintiff, the day.
I assume it's fine with Mr. Goldberg.
All right. I think that's far out enough. And if a resolution occurs before, or if it's a dismissal, please submit it. But August 21st, 2023 at 9 a.m.
Ms. Houston, I'm going to put you in a breakout room to talk briefly, and Mr. Bornkamp,
Okay.
I will follow up with you, okay?
All
In
right,
a
thank you.
breakout room, if you can hang a few minutes.
Sure.
I'm sorry.
Thank
Can you give me your phone number, Attorney Phillips, or you can email me if you have my pleadings. It's actually better.
I really actually have nothing other than Mr. Goldberg's pleadings. Let me chat you, okay?
Okay, that sounds good. Thank you.
Thank you, Attorney Bornkamp.
Thank you.
Ms. Vallis,
Sonia Williams.
And you have what? I see you had your hand up. How can I help?
I'm here for court. My case number, the last 3 numbers is 685.
All right, we have you checked in. You have an attorney?
No,
Requesting one?
no. I don't understand why I'm here.
Okay. I'm going to invite you into legal aid lobby.
I no,
You
I
guys can
don't
call my case.
I don't need legal aid. I know I have to move. That's why I understand why I'm here.
Okay.
I'm in the process of moving already as we're speaking.
Okay. Well, we'll figure it out shortly. I have you checked in, and when the attorney for the plaintiff comes in, I'll have him.
They say that he's there, Mr. Andre Lombard.
It looks like Attorney Cox is the attorney representing Charles Peacock.
It says Andre Lombard on this paper.
All right. What's the case number? Is 23346685?
Yes,
Peacock
yes.
versus Williams. All right, I have you checked in. I'll call your case. I'm the attorney for the plaintiff arrives.
Okay.
Thank you. Mr.
Your
Brown?
Honor, sorry to interrupt. Can you please, Miss Janice Ojiki in breakout room number 3? She was kicked out.
Hello? Hello?
Brown? Mr. Hardiman, hello?
You guys didn't call my case. I was supposed to be at 9:01.
Yeah, we didn't call your case yet.
And my attorney said she was trying to get through. She's not able to get through.
Who was your attorney?
Vanessa Fluker.
Okay, yeah, she should be able to get through. There's nobody in the waiting room. But I have you checked in.
Okay. Thank you, sir.
And Fluker is here. I'll put her in with you in the breakout room. Good morning, Attorney Fluker.
Good morning. How are you this morning?
Doing well. How are you?
I am not going to complain.
Have you renamed? I'll put you in. Can I put you in the breakout room with Mr. Hardiman?
Thank you.
Well. Okay, sending you you should see an invite. Attorney
Yep,
Fluker.
I got it. Thank you.
You're welcome. Mr. Brown. Good morning. Let's see if we can get you unmuted. Okay.
Could you send me to the breakout room where you just sent Ms. Brown a few seconds ago?
Okay, do you want to speak to an attorney or do you want to speak
Yes.
to the landlord's attorney?
No, just send me to the breakout room where my niece and I believe our attorney is.
Who's your attorney?
Phillips, I believe. You just sent Ms. Brown to the breakout room?
I'll send you to the UCHC lobby.
Okay.
You'll see a prompt. Do you see it? Do you see it? Let's see. All right, Mr. Stewart.
Yes.
See you at your hand up. Good morning.
Good morning, Your Honor. I was just making sure I was checked in. I was having trouble getting in the courtroom this morning.
All right, and do you have an attorney?
No, sir.
Are you requesting counsel?
Actually, Your Honor, I just want to get the ordeal over with. You know, I'm already planned on moving. I just got a job out of town. I just need a couple of, some time to get my stuff out of here and acquire a place out of where I'm living at now. We can just,
Okay, is Rashida Snodgrass here?
Mm-hmm.
Okay, Ms. Snodgrass.
Yes, Your Honor.
Good morning.
Good morning.
I'm going to invite you into a breakout room with Mr. Stewart. See if you all can work something out. Let me know if you can. Let me know if you can. If you need some assistance crafting an agreement, Mr. Stewart can get an attorney and you all can get some assistance because you don't have counsel. So let me know.
Okay.
What you all with move out dates. 10 days is already the minimum move out date. So if you're negotiating 10 days is really what the court's going to give you anyway. So
Okay, thank you.
And good luck. Let me know. Just pop your hand up. One of you all are just no court when you're
Okay,
ready.
thank you.
For those who know what I'm talking about, there have been a few incidents this morning, and I think if anyone knows, it may not be a bad idea to just cut off all the videos, everyone's video, but I'll leave that up to Jeffrey White. Oh, we already spoke to Jeffrey. I spoke to Jeffrey White. Ms. Freeman.
Yes, Your Honor. And speaking with Ms. Clark, it's come to my attention that there's been a slight clerical issue potentially regarding naming attorneys of record. I did send a letter to the court explaining what we believe happened. We did not file or initiate this lawsuit on behalf of the estate of George Sarakis. I'm not certain how we've come to be listed as the attorneys of record. We are, however, attorneys of record on behalf of the estate of Aurelia Peacock, and I can give you that number.
Is that 685?
Yes.
Is that the address, Your Honor, or the case?
No, that's the case number, 685.
I have a 6413. Hang on.
Let's see.
No, you're right. I apologize, Your Honor. I was incorrect. It is 668.
No, 6685, yes.
Ms. Williams, yeah, thank you, Ms. Williams, because she brought it to my attention. 6685. All right,
Yes.
let's see what's going on with these two cases. Six, 685. All right, is Attorney Harker here? And good morning, Attorney Rabbits and Attorney Lawon.
Good morning, Your Honor. Your Honor, we have one case where we're trying to find out how much money is in escrow account. We can't tell on the ROA anymore. Can you tell on your computer as to how much is in the escrow?
We'll check. 1 second, Attorney Rabbits. And if you chat, let's see. Can you chat that request to us? And I'll send it over to the clerk in the meantime.
Okay.
All right. So 685, I have Sonia Williams. This is Charles Peacock, personal representative on behalf of the estate of Aurelia Peacock.
Yes.
Versus Sonia Williams on Waverly.
Yes.
Okay. Let's see what's 6-8. Yeah, I think it's just a clerical error on the docket sheet. It has to be. Six, 8, 5. All right, and our party's ready. Are you ready on that case, or do you need to speak to?
Could I
Ms.
speak
Williams?
to Miss Williams, Your Honor?
Absolutely.
Thank you.
Ms. Williams?
Your Honor, is it possible for me to speak to the attorney for Water's Edge on the Dorian Hardeman case?
Yes, 1 second.
Okay, great. Thank you.
Invited her to room 12. And what's going on? Is Ms. Clark? Should I invite her back to the main session, Ms. Freeman?
She is still in the waiting room that I was previously in, Your Honor.
Okay, all right. That's fine. Attorney Luan.
Yes, Your Honor. I believe we are ready and the parties are here on 5142 Gadsden versus Taylor.
Calling case number 233454142. This is Nicole Gadsden versus Mercedes Taylor and all occupants.
Good morning, Your Honor. Suzanne Steppich Lawan, P 48702, Michigan Legal Services, on behalf of the defendant, Mercedes Taylor. And Ms. Taylor is in the courtroom with us. Ms. Taylor, will you unmute and state your name for the record, please?
Mercedes Taylor.
All right, good morning, Ms. Taylor.
And I believe I saw Ms. Gadsden somewhere too.
I think I saw Ms. Gadsden this morning as well.
Good morning.
I'm here. Good morning. All right, were parties able to work out some type of agreement or resolution?
No, Your Honor, this case, the more we get into it, the more complicated it becomes. We only learned yesterday. We've not been able to get the court file despite requesting it 3 weeks ago. So we haven't seen the pleadings. We only saw yesterday that a deed had been executed in February. We had also filed a claim of interest in February. I've spoken with the land bank. This is a case where the home was purchased by a 501c3 corporation, which was dissolved, and we have not been able to obtain the dissolution plan for the property. According to the articles of incorporation, it was to go to other nonprofits with similar purposes. And I spoke with the land bank and they believe maybe it should have reverted to them upon dissolution of this corporation if it had not been sold to my clients as promised. We are preparing a quiet title action in circuit court. So we ask that this either would be dismissed or adjourned for such time to let us finish the quiet title action.
So Ms. Gadsden, are you the owner of the property at 12376 Indiana?
Yes, I am the new owner of the property. I purchased the property before she put in a claim of interest. Actually, she put a claim of interest in after I sent the eviction letter and the letter and letting her know that I was the new owner.
But Your Honor, if I might respond, this was owned again by a nonprofit corporation who then sold it after it had already been promised. It was sold by the corporation after it had been dissolved, and the articles of incorporation say upon dissolution of the corporation that any remaining property would go to nonprofits with similar purposes. Again, the land bank is involved. They are doing research. They have been able to say that my client brought the property into compliance as of July 16th, 2020, and they were not sure why the title went the way it did. They believe maybe it was some confusion during COVID.
I was told, I'm sorry if I can speak. I was told that Ms. Taylor didn't do what she was required to do, which was in 6 months and she did it in 2 years, but then still didn't do everything she was told to do. The water bill is now $5,000 and the taxes are high as well. The house was facing foreclosure, and that is why the nonprofit went ahead and sold it because they didn't want that foreclosure in their name. They also didn't want the county to come back to them with those past due taxes.
And Your Honor, again, I don't feel like this is the proper place to litigate this. If we need to decide title, it needs to be an action in circuit court. But United Community Housing Coalition and some other organizations had been trying to help Ms. Taylor get assistance, and actually had assistance arranged for the water bill and the back taxes. And the Linda Gadsden, who was the resident agent of the corporation at the time, refused to put she was asked by both United Community Housing Coalition and other organizations to put the water bill and the taxes in Ms. Taylor's name, and that they would be paid.
Linda
And she
Gadsden,
refused.
she said that she would transfer it to her name, but she refused to pay the $150 security deposit so that she could transfer it. No payment has been made on the water bill at all since the water got turned on legally. The first 2 years, the water was on and showing no usage. And then when it finally showed usage, now it's standing at $5,000. Only the security deposit to initially turn it on has been paid. She didn't start seeking help for this until recently.
And Your Honor, I have a receipt for the $150 deposit that was paid. I also have text messages from Ms. Gadsden saying that she wanted to control when things were paid, so she would not change the name. This is a.
Now I've purchased the property for $3,000 before she put any type of claim of interest in it. When I looked up the property, it was free of any liens or any interest when I purchased it.
Okay, this is a title dispute, and I'll adjourn it. You said a quiet title?
A quiet title. We're preparing it right now. We only learned about the second deed yesterday. Because when we had searched, we did not see it.
When I search it, I've seen it for like a month. I've seen it since. So I don't see how I can see it. You can't.
What was the building at risk of foreclosure as a nonprofit?
I'm sorry?
What was at risk of foreclosure?
Apparently there were some back taxes. Again, the taxes were being held in the name of the corporation and they would not transfer it. And so there was a risk of tax foreclosure. And we had filed a claim of interest so that we could get those taxes paid.
I was just wondering how you even getting that, unless you're not paying your garbage.
Right, she hasn't paid.
Water goes over to the taxes, but all right. I'm going to adjourn this matter for. We can adjourn it briefly. The quiet title is done. Please present your deeds. I'll adjourn it for. I'll adjourn it to June 13th.
Okay.
Thank you, Your Honor. And we will get that filed. If you could set that file aside, I can send someone up to get a copy. Like I said, we requested it from the court 3 weeks ago and still haven't been able to get it.
We're here every day.
Awesome. Thank you so much.
I have a question. So with the quiet title, do I need to do my own quiet title or do I need to just defend that?
She hasn't filed one yet, so there is no quiet title. But in the event it is filed, then you probably need to, you would have to respond, but that's separate from here, and I can't give you legal advice. So, I'll see you all back.
And is it too late for me to come with an attorney as well?
I would recommend you have an attorney. I think you should have an attorney.
Thank you, Your Honor. And Ms. Taylor, I will talk to you later today.
Thank you.
All right, you all have a great day.
Thank you. Have a good day.
You're welcome. Attorney Snyder.
On Ms. Biggs, I don't believe she appeared. So we're requesting a default 6, 4, 7 are the last three.
On Connie Biggs,
Yes.
is Connie Biggs present? Case number 2334-6647, Oakland Townhomes versus Connie Biggs.
Thank you, Your Honor. Jackie Snyder Palmer on behalf of Mark Wasbury, 82554 is my P number, and we represent Oakland Townhomes in this matter.
Good morning. Is Connie Biggs here? Does anyone reside at 2390 Ewald Circle? Defendant has failed to appear. Counsel, are you requesting a default judgment?
We are at this time, Your Honor. There is a fairly small balance of sorry, with court costs. So it looks like the balance is $25 and then court costs are $159 for a total of $184.
Was this matter filed for $25? No, it was filed for $192.
Yes. So there's been a payment made and then looks like she hasn't paid the rest.
It's $184.
Mm-hmm.
All right, defendant must pay. Default judgment is granted. Defendant must pay $184 by May 30th.
May 30th.
May 30th.
All right.
Saturday and Tuesday and Monday, 29th is Memorial Day.
Yes. Thank you, Your Honor.
You are welcome.
You have a great day. I'll see you later.
All right, take care.
You too.
Attorney Rabbit. Attorney Rabbit, are you all, our party's ready on cheese?
Your Honor, we're waiting to find out how much is in the court escrow account. I sent a chat to the court reporter. We've not heard back yet.
I wouldn't have that information, counsel.
Oh, how could we find out how much is in the court escrow account? It doesn't show up on the ROA anymore.
We handle it. I'll ask the clerk. Attorney Rabbit. We have, hold on one second, please. There's $800 in escrow.
I'm sorry, Your Honor. This is Ms. Cheese. It's more than $800 in escrow. It's over $5,000 in my escrow account.
We'll post it to
The
the court.
$800 was the last payment that I made on the 5th or something of this month.
So are you saying that you posted more than $800 to the, okay.
I have my paperwork in the car, how much is in my escrow.
All right, so you posted $800 on the 11th of May. It looks like you posted $590 on April 4th. $22.76 on March 14th. $7.76 on February 3rd. Oh, there's one more in there with this. It's $176 on January 5th, and the 600 on January 3rd. Oh, it's all right. Sorry. 600, 176, 776, 2276, 590, and 800.
I have that totaling 5,218. Mr. Santiago, and let's go back into a breakout room.
Sure. Lee, give me a second. Let me ask Ms. Cheese that question that about the security deposit.
I've got the answer, Robert.
Okay,
I've
thank you.
got the answer.
Okay.
Madam Court Reporter, for everyone who checks in, we're going to disable their video until they identify themselves.
Okay, and I was trying to check everybody in when they come in by their name. If their name wasn't on our docket today, I'm not letting them in.
Okay.
I was checking the names and then I let them in.
Okay.
Awesome.
That works even better.
Okay.
Attorney Ty Linda, are you?
Yes, good morning, Your Honor.
Good morning. Is Sona's Mobile Restaurant here?
Your Honor, I see Mr. Troy Lincoln here, Your Honor. If I may, Your Honor, there's been some, Mr. Lincoln appeared at the last court date. What I asked the court to do is just give us a court date in a couple of weeks. I've got some issues and some matters of proof to work out with Mr. Lincoln. I believe we can resolve this matter. Could I have another court date of about 2 weeks?
2 weeks.
Your Honor, I would like to have this resolved today if it's possible, Your Honor, please. Because this is a simple matter here, Your Honor. Let me explain briefly, Your Honor. I was given notice by the landlord.
If I may, Your Honor, before
December 23rd. You understand?
Let's call calling case number 233-44001. Joy Plaza LLC versus Sona's Mobile Restaurant. And
yes,
all
sir.
233-440.
Who's all occupants, Your Honor?
Everyone else who's occupying the property other than the LLC.
There's no other person occupying the premises.
Okay, all right. Can we place the time? Counsel, can you place your appearance on the record and then
yes, sir.
Lincoln, your name.
Yes, good morning, Your Honor. For the record, Paul Talenda on behalf of Joy Plaza, T72495.
Thank you, counsel. And Mr. Lincoln, can you state your name for the record?
Mr. Troy Lincoln.
Thank you, Mr. Lincoln.
You're welcome, sir.
All right. Counsel, you're requesting an adjournment for about 2 weeks?
Just 2 weeks, Your Honor. There's Mr. Lincoln has abandoned the property, so he's out of the property. The issue we have as to whether or not there are any damages and how that reflects on whether or not there is a security deposit. I have to reach out and get matters of proof from Mr. Lincoln, as well as confirm them against what my client has presented to me. So I think that's just a matter of an issue of quick proof that I believe that Mr. Lincoln and I can discuss on the phone and have resolved before the next court date.
Your Honor, we do not need 2 weeks for this to be approved, to go through and have a look at it. I would like to have this case resolved as early as possible, Your Honor, please.
Your Honor, here's the issue here, Your Honor, is that I have some damage and some missing property from the location, and I don't want to have to proceed to a judgment today if Mr. Lincoln has in fact returned that property or he wasn't the one, or there's been some misunderstanding as to the property itself. I don't believe we can resolve this today based on those issues.
Your Honor, I don't understand this. First, I would just hear me first, Your Honor, please. I'll be brief as possible.
Very brief, because I understand it. He said there are some issues or some damage he wants to make sure has or hasn't occurred, and he doesn't know what's going on with the items. So I'm going to let you speak, but I understood what the attorney was saying. I think you did too.
Yes, I do, Your Honor. Okay, Your Honor, the landlord called me on December 23rd. He was not just going to renew my lease, and he wants me out. I said, no problem, Your Honor. I I remove everything out of that place, all my property that I bought, and I vacate the premises before January the 10th. So actually, he had my deposit. So when we spoke the last time, Mr. Paul told me, we went to the break room, I explained to him that his client still owed me my deposit. So now that I got 2 notices inside here now, Your Honor, stating that they want all occupants of the premises to be here. I am the sole owner for Sonos Mobile LLC.
Was it another separate lawsuit filed as all occupants, counsel?
Yes.
No, Your Honor, it's the catch-all. It's the all Sonos Mobile and all occupants.
Well, what occupants?
Well, this is the
I just wanted to
part
make
of
sure there were 2 ongoing cases, counsel.
No, Your Honor, just one.
Okay. All right, because all these cases have all occupants as the catch-all, as stated. It can be this person and all occupants, because it's one person on a lease and maybe their kids, the grandmother, whoever it may be, all occupants. So I'm gonna grant a brief adjournment to June 1st.
Thank you.
We still go on Zoom June 1st. June 5th, we'll be in person, so.
Thank you, Your Honor. We'll see you then. Mr. Lincoln, I'll call you in advance. We'll talk.
Thank you.
Thank you, sir. Take care.
Attorney Deedlin?
Yes, Your Honor, I had to change courtrooms briefly, and I was wondering if I could get breakout room privileges again so I could speak to my client.
Yeah.
Thank you.
Well, Attorney Freeman?
Yes, Judge, I had an opportunity to speak with Defendant Williams and we've come to an agreement and I'd like to put the terms on the record. She is still in the breakout room.
Okay, let's see. Let's get around it. Madam Court Reporter, do not let in Ariel Hoffman.
I didn't let them in. Someone else must have let them in because I looked her up. I didn't see them on here. I didn't see them on the the search, attorney search.
Okay, yeah. Okay, good.
I searched them on the Bar Journal.
Thank you. Calling case number 23346685. This is the estate of Aurelia Peacock, Charles Peacock versus Sonia B. Williams.
Yes.
Good morning, Your Honor. For the record, Attorney Jacqueline Freeman, P84-916, on behalf of Charles Peacock, personal representative for the estate of Aurelia Peacock. I am standing in for Attorney Andre R. Laubeck today. I've had an opportunity to speak with Ms. Williams. The suit was initially filed for complaint for possession only in an effort to assist an estate in wrapping up any sort of assets and liquidate them. She has communicated to me that she is in the process of vacating the premises in question. She has found another place to live and is currently on course to be out of the property by June 15th. We've agreed to a conditional dismissal in the event that she is gone by the 15th. This case will be dismissed. We will not have any need to take any further action against her, and this case will be resolved.
Okay, and is 4B checked on the conditional dismissal?
That is correct, Your Honor.
Okay, and 4B, Ms. Williams, is stating that a judgment and a writ of eviction can be filed at the same time. So we wouldn't have to come back to court in the event that you didn't vacate by June 15th.
Okay,
There would be an application of writ. But if you vacate by June 15th, this case is dismissed.
okay, okay, and it won't be on my record. That's my
It'll be,
concern.
it'll be on your record as dismissed.
Okay, but it won't be on my record as something bad.
Like a judgment is not being entered right now. It's a conditional dismissal. So there's already been a case filed, but the resolution is probably what whoever is searching your records is looking at. And the resolution is going to say, if you vacate by June 15th.
Okay.
In the event you don't, and plaintiff files an affidavit saying that you did not vacate, then a judgment and a writ of eviction could be filed, which will be filed in your name.
Okay, okay, I got you. Thank you.
Okay, you're welcome. And Ms. Williams, do you give the attorney permission to sign your name?
Well, she's not my attorney, but
No, see, we're not in person, so
yeah.
in order, either she emails it to you, you print it out, you sign it, scan it, email it back to her,
Or
you give her permission to sign your name.
okay, I give her permission to sign my name.
All right, this is just for no dismissal. So
Okay,
with the terms that were set forth on the record, she'll put it on in an agreement, and she won't put anything that's not in this agreement. So
okay,
And Miss
All right.
Williams, I will email it to you before I sign your name. You can let me know.
okay.
Thank you, Judge.
you're welcome.
All right, thank you.
You're welcome.
Judge, sorry to interrupt. I'm trying to get my client's attention to go into a breakout room for a moment. Ms. Cheese, could you please accept the invitation to go out into breakout room 6?
An attorney Horka, you have I'll let Attorney White in. Attorney Horka, you have Jeffrey White here. Who wants to speak to you? Good morning, by the way.
Good morning, Your Honor. I'm not handling Aaron Cox's today. Brian Gertis here, but I had some 8:30 first hearings from Mark Lando's office that were labeled under a different judge. I apologize about being late.
No, I had a labeling issue this morning too, so it's no worries. Sometimes things get mislabeled.
Yes, Jeffrey White is with me. Well, he's a case I'm handling.
Okay. All right, so I'll invite you all. You have breakout room privileges, Attorney Gerber? He's in room 14. You should be able to move to room 14. I'll invite you. Just so you have. Yeah, if you need to. The EK case. So,
Okay.
Attorney Jarbo, are you ready on your matter?
I believe he had said that we were gonna do a,
Yes, Your Honor, we're ready.
Calling case number 2334-61, United Solutions Group versus Janice Ogiki.
Ogike.
Ogike, okay. Good morning, Ms. Ogike.
Good morning, how are you?
Doing well. Good morning, Mr. Jarbo.
Good morning, Your Honor. Sam Jarbo, P84564 for the Plaintiff United Group Solutions in this matter.
Thank you. All right.
Your Honor.
It's not fitting with any of the documents.
Apologize. Your Honor, we have a conditional dismissal agreement with item 4B checked off. Do you want me to place those terms on the record?
But yes, has she defended reviewed the terms?
Yes, we've both went over the terms. We're both in agreement of the terms, and she can confirm that.
Okay. All right. Can you place this, what are the basic terms?
Your Honor, we're gonna agree to a payment plan of $750 every 2 weeks until rent is caught up. It's gonna be a period from December to June of December of 2022 to June of 2023. And then, as rent comes thereafter until she's caught up and she can start making normal rent payments with item 4B checked.
Okay, and what's the total amount owed?
It'll be $9,000 as of June 1st of 2023.
So it's not 9,000 yet.
I'm sorry, Your Honor. I apologize. Hold on. There's a it's gonna be.
I mean, 8,100.
No, it's gonna be. I apologize. So. It's the late fees aren't 100, they're 50, so it's going to be $6,650. I thought the late fees were $100 a month or $50 a month.
Okay. So would you say it would be?
So $6,300 in rent, Your Honor, and then $300 in late fees, so $6,600.
Okay, 6,600. All right, that's the total amount, and $750 every 2 weeks until this balance is covered, plus the monthly rent.
Correct.
And is that your understanding of the agreement?
Yes, sir.
Okay. And does Attorney Jarbo have permission to sign your name on this conditional dismissal form?
Yes, sir, that's fine.
Okay. In the event you fulfill this obligation, your case will be dismissed. In the event one of these.
You can, if you want, if she's comfortable giving you, or you can save that, or you can have go into work and verify.
Thank you, Your Honor. I'll submit that later today.
Okay. I have to mute you because there's some background noise. But in the event one of these terms are breached, an affidavit can be filed where a judgment and writ of eviction can enter at the same time. So do you understand that? And do you give consent? Question number one, do you understand that? Question number two, do you give Mr. Jarbo permission to sign your name on the conditional dismissal?
Yes, sir, I do. And yes, that's fine.
Okay. All right, the court is satisfied. Good luck, take care, and have a great day.
Thank you.
Thank you, Your Honor.
Cool. Mr. Raptopoulos.
Your Honor, waiting for Robert Santiago to come back.
Okay. Okay, I see Kimberly O'Brien.
Good morning, Your Honor.
Good morning. So you on 921? You're on.
Yes, James Stump, representing the defendant, Mr. Raptopoulos. My PIN number is P85529.
And who's representing? I know Tamika Horn, Judge Horn. I'm sorry, Attorney Horn.
Oh,
substituted out this case, so who's?
They substituted out. It was Shakira Hawkins.
Okay, and is Ms. Hawkins here this morning?
Your Honor, I don't see her. All we're asking for is a transfer of this case to circuit court because it involves foreclosure proceedings. And required under the MCL, all foreclosure proceedings brought under the General Property Tax Act must be held at circuit court, who retains jurisdiction for the law.
Is there an ongoing circuit court proceeding right now?
No, there's not, Your Honor.
And what, I mean, this is a termination of tenancy issue, but is your client claiming to own the property?
Yes, Your Honor. Bought it in 2000.
Okay, so this is really not going to get anywhere in my courtroom until the title is determined.
That's correct, Your Honor. That's why we want to take it to circuit court.
Okay. What's the attorney? Let's see. Ms. Hawkins, have you tried to get a hold of Ms. Hawkins, Attorney Hawkins?
Yeah, I've talked to her and, she did file pleadings as late as yesterday evening.
For this matter, are you all in agreement to remove this to circuit court?
No, she disagrees. I asked for a stipulation agreement and she says no, but her arguments are contradictory because she initially argued this belongs in circuit court. Now she says, oh, no, this doesn't belong in circuit court.
Is she planning on appearing this morning? Do you know?
She had notice.
Okay. I'm not going to call this case just yet. I'll give her a second to appear. If you want to give her a call, because I may end up removing this, but I want to get her perspective on this because I'm not going to determine title. So it sounds like this will be removed, but I'd like to get Ms. Hawkins. So if you can give her a call, I don't know if you have a copy of the substitution in your file, but give her a call if you can get her here. If not, I'll recall it after I call a few defaults.
Your Honor, I don't have her number. I only have the number for Tamika Horn. Does she have do you have a number for her?
Yeah, let's see. I think I chat. Give that a shot, and I'll keep the file close, counsel.
So we don't have a number for her, or you don't want me to call?
I sent it to you in the chat.
Oh, okay, all right.
Number ending in 0444. You see it?
Yeah, I got it. Thank you. Okay, I'll.
Give it a shot and then I'll recall it.
Okay, thank you.
Call. Attorney Gertuck.
Yes, Your Honor.
Everybody's ready on white.
Yes.
On page number 2334-6678. This is Costco DG LLC versus Jeffrey White.
Ryan Gerda, P 80756 on behalf of the plaintiff.
Mr. White, can you state your name for the record?
Jeffrey White.
Thank you, Mr. White, and good morning. Were parties
Good
ever
morning.
work out a resolution in council?
Yes, Your Honor. Parties have an arrangement. Although this is a termination and tenancy case, there's an agreement that involves the payment of rent in full and continued occupancy. So we're going to do a conditional dismissal of this case. The payment is currently posted to the accounts, just pending being cleared. So as long as it clears, this case will remain dismissed.
Okay. So can we put a date on the clearance?
Yes, 10 days would be more than enough. And box 4B will be checked.
It'll be May 30th regardless.
Okay.
All right. 23, 4B is checked. Okay, it seems like you all have this already worked out and the amount is already transferred. This is a conditional dismissal, so in the event that payment is made by May 30th, your case will be dismissed. In the event there are any issues, you will have until May 30th to rectify those issues. And by May 30th, the payment isn't made, then a judgment and a writ of eviction could follow.
Yes, sir.
Mr. White, do you give Attorney Gerda permission to sign your name?
Yes, sir.
Court is satisfied. Any other questions?
I do. No, sir.
No, Your Honor.
All right, good luck, Mr. White.
Thank you, Your Honor. Thank you, Mr. Gerda.
Thank you.
Is Tuesday Davis here? All right, DeShante Gray. Is Adrian Johnson here? Adrian Johnson.
This Mr. Gray.
Or is Adrian Johnson here? Guess we could admit call in. We've been getting bombed by people zooming in who weren't in this courtroom. So we've tried our best to name everyone who's here. There's several people in the waiting room. I've sent them messages to name their devices. Some of them may not be able to name their devices. If we call default judgments, I have to let these people in. So risk that we run. I'll let these people in and then we'll see who's here and I can start calling defaults. Attorney Roberts, are you ready in your case?
We are ready, Your Honor.
Okay, I'll call this case. Calling case number 22395065, Al Hadi Investments versus Asia Cheese.
Your Honor, Lee Rabbits, P25314. On behalf of the plaintiff, Mr. Santiago's on the other side.
Good morning, Your Honor. Robert Santiago, Michigan Legal Services, P57157. On behalf of the tenant, Asia Cheese, who is present. Ms. Cheese, could you please state your name for the record?
Asia Cheese.
Good morning, Ms. Cheese.
Hello.
All right. Where are we on this matter?
Mary, the parties are going to enter into terms of a conditional dismissal. Box 4B will be checked. The conditional dismissal will note the total due and owing is $5,996. Of that sum, $5,218 is in the court escrow account, and the conditional dismissal will provide that money should be immediately released to the plaintiff. The remaining balance of $778 will be paid by the tenant within 30 days. Box 4B will be checked, and the plaintiff will agree to accept payment for any remaining balance from a third party.
Okay.
That is
So it's-
accurate, Judge.
All right, 30 days puts us at June. Well, May has 31 days, so it's June 16th.
That's fine, Judge.
June 16th, and plaintiff must accept payments up to June 20th, up to that Monday. It's like Father's Day, and then Juneteenth, and then June 20th, so.
Okay, that's fine.
Okay, all right, Ms. Cheese? Do you agree with this? All right, let's get you unmuted, and you do have counsel. Ms. Cheese, do you
Yes,
understand?
can you hear me?
Yeah, I can hear you.
Okay.
Do you understand what's going on?
Yes, I do, but I do want to know for the remaining balance, can it be like if I pay like something like it maybe every week, or do they want it all at once?
You and I can talk, Asia. I think, it's 30 days. If you're able to pay off a little bit each week, that's fine too, but we can talk further, okay?
Okay.
Okay, all right. And do you give Mr. Santiago permission to sign your name?
Yes.
All right, well,
Judge, can I get the balance again that's in escrow, because I am going to prepare the CD.
5218. And do you have a pen handy? Yep, Judge. That top box. Are you ready, Mr. Santiago?
I am.
All right, 600, 176, 776, 2276, 590. That was 590 and 800. So not two 590s, but someone chimed in, so I wanted to make sure you heard it.
Okay, so I have 600, 176, 776, 2276, 550, and 800. There was some confusion at the second to the last one.
It's not 550, it's 590 on the left, on the second to last.
Thank you.
You're welcome. All right, the court to enter this conditional dismissal. Good luck.
Thank you. Thank you,
Thanks,
Robert.
Thanks, Lee. Ms. Cheese, can you go into the breakout room we were in? I will meet you in there.
All right, let's see. 210. Shante Gray. How can we help?
Hey, how you doing?
Doing well. Were you all able to? You still had your hand up? Have you all come to a resolution?
You all who?
You and is Adrian Johnson?
No, no.
All right, yeah, I have to let's start that.
She told me that her agent at the FIA was going to assist her. She needed some type of Letter from the court, I forget what she said.
Okay, I'll call your case shortly. I'm going to.
I believe she said a summons. I think that's the word.
I'll get it. She needs a judgment, but
Right.
I'm just trying to regulate who's coming into the courtroom right now.
Okay.
And everyone will appreciate it. Ma'am, B22. What, Madam Court Reporter, we have to let everybody in before we call defaults. I don't see any other way.
Okay, well, go ahead, Judge. Call them in. You know what to do.
I'm just nervous.
I know. I didn't see a Beasley on here, but she could be in the wrong courtroom.
Yeah, it might be off.
Hello? Hello? Yes. Hello? Yes.
Yes, it's somebody looking for Beasley.
Oh, no, ma'am.
You said no?
No.
Okay,
No.
sorry.
Please listen, please, that's not the court. That's another person in Zoom. Maggie Beasley. I have you all checked in. Please listen for addresses if this is your case. There's some 9 and 8:30 cases that need to be addressed. Everyone should be checked in. There's only one case at 10:45. Everyone else's case is either at 8:30, 9 o'clock, or 10 o'clock. We have everyone in here. So I'll put on like default judgments. Please mute your device. Please mute your device.
Oh, sorry.
And Ms. Beasley, what case are you on?
Yes, I was just saying my friend phone ain't working, so I called on my phone. His name is Corey Lewis.
What case is he on? And where is Corey Lewis? Oh.
He right here, but his phone not working.
665.
Okay. 665.
Yes, sir.
All right, Mr. Lewis,
Yes, sir.
do you have an attorney?
No.
All right, would you like to speak to the plaintiff's attorney, the landlord's attorney?
Yes.
All right. Maggie Beasley, Miss Haddad. Miss Haddad, good morning. I want to put you in the breakout room. Breakout room number 8.
Danielle McCurry, I'm here.
Hold on, please. And I'll get to you, Attorney Stump, shortly.
Okay.
Fine, Danielle. Where's Danielle Beasley on the list?
No, Danielle McCurry.
Is Danielle McCarty?
McCurry, yeah, she's.
Oh, Corey Lewis. Okay, it was changed. Great.
Yeah.
All right.
Corey Lewis, yeah.
Okay. All right. Thank you, Madam Court. All right. Attorney Stump.
Yes. Ms. Hawkins is present. I was able to reach her.
Attorney
Good morning. I apologize. I wrote down May 18th.
That's all right. That's why we make an extra phone call. All right, calling case number 233. Do you all need to speak? Are you all in well communicated?
I sort of stated my case in summary. I guess we're waiting for Ms. Hawkins.
Ms. Hawkins, I still need to call the case, but before I call the case, would it benefit of you all having a conversation off record?
I'm willing to discuss to Ms. Hawkins.
That's fine.
Okay, and if something comes out of it, great. If not, I'll just call the case anyway. So,
okay.
All right. Room 12. You all should receive it, right? Just pop a hand up, a digital hand, and I'll recall your case. We need to get through some of these cases. Is Adrian Johnson here? Adrian Johnson. Calling case number 2-334-6639. This is Deshante Gray versus Adrian Johnson. Can you please state your name for the record?
Yes, Deshante Gray.
All right. Is Adrian Johnson here? I don't see any Adrian Johnson present. Okay, counsel, are you requesting a default judgment? Mr. Gray?
You say, am I what now?
What would you like for the court to do?
I guess I don't know. Yeah, make a judgment.
All right, how much time? Let's see, this is a complaint for non-payment of rent. How much rent is owed?
6 months. Let me see here. 5 or 6 months. 6 or 7 months there. I believe it's like 3,500, 4,000. It should be, yeah, this month, this is a new month, it's 4,000.
It's not a new month. It's the
I mean,
middle of the month.
it's into the new month of May. I did that paperwork in April.
Yeah, I didn't know what new was, what you were referring to.
Okay,
So,
okay.
it's paid through June 2022. So July, August, September, October, November, December, January, February, March, April, and May. That's 11 times.
Oh, 11 times 5, that's 55 then.
Has the payment been made?
I didn't hear you.
Okay. Are you sure that's accurate?
Yeah, that's accurate. It's 500 a month times 11, 55.
That's what was on the complaint. I have proof of service in the file. So how much time do you want to give Miss?
Well, she says that her agent's going to help her out. I don't know. I guess what that takes. I heard you say 10 days earlier.
10 days is the statutory minimum. That'd be May 30th.
Okay, can we try like right after the 14 days? That'd be like June the 3rd or something.
Okay, we can do June 2nd is a Friday, which would make it June 5th, where you would be able to file a writ.
Yep, June 5th.
Okay. So I'll put the date as June 5th. I'll put, she can pay up to June 5th.
Okay.
So default judgment is granted. Defendant must pay $5,500 by June 5th, 2023, or a writ of eviction can issue.
Okay.
All right, and make sure you submit a default judgment to the court. A judgment by default.
That's me, right?
That's you. Yes, sir.
Okay.
That's the language.
Where I get that down at 36th District?
Yes, on the second floor.
Okay.
All right. All right, good luck, Mr. Gray.
All right, thanks, man.
Are you free to go? Is Tanisha Akins here?
Your Honor, we are here for the plaintiff on Tanisha Atkins. I'm not sure. I don't see Miss Atkins or her attorney on the Zoom.
Yeah, I called defaults I'll call defaults at 11 in your case, but I saw you were here, so I was just checking to see if she was here. Wow.
Thank you, Your Honor.
Just let me know if she pops up. Is Tuesday Davis here? Tuesday Davis. Good morning, Mr. Elam. Tuesday Davis.
Good morning, Your Honor.
Good morning. Calling case number 2334-2139. This is Gerson 7 versus Tuesday Davis.
Morning, Your Honor. Brian Gerda, P 80756 on behalf of the plaintiff.
All right, is Tuesday Davis here, or anybody who lives at 16845 St. Mary's? All right, doesn't appear that anyone is here from that address. Counsel, are you requesting a default judgment?
Yes, plaintiff moves for default judgment possession.
Default judgment is granted. Defendant, it's a termination of tenancy case. There's no amount to redeem. However, defendant must vacate by May 30th, 2023, or writ of eviction can issue. All right, thank you. That's case number ending in 139.
I have this as a non-payment.
139?
Yeah.
Excuse me, it is a non-payment. What is, do you have a rental amount, a rent to retain?
$411.11. 160 in court costs. Total $571.11.
Thank you for catching that. Default judgment is granted. This is a non-payment of rent for $571.11 must be paid by May 30th, 2023, or a writ of eviction may issue. There is a proof of service in the file. Thank you, counsel. Is Shea Reeves here? Shea Reeves. Calling case number 2334-6643, Sheridan Court versus Shea Reeves and all occupants.
Brian Gerda, P 80756 on behalf of the plaintiff.
Thank you. Is Shea Reeves or anyone on 2nd Avenue, 4417 2nd Avenue? No one is responding to the call of court. Counsel, you may proceed.
Plaintiff moves for the entry of default judgment possession. This is a non-payment rent case, $5,908 in rent due knowing. I'm sorry, that's the total amount. $5,750 in rent due knowing, $158 in court costs for a total of $5,908.
All right, thank you. And that amount is to be paid by May 30th, 2023, or a writ can issue. For the record, default judgment is granted. It's case number ending in 643. Is Magali Moore here? Magali Moore. Calling case number 2334-6674. This is Mondongo Development Group versus Magali Moore and all occupants.
Brian Gerda, P 80756 on behalf of the plaintiff. We had previously submitted dismissal on this one as a tenant vacated.
Okay, so, okay. Well, this matter is dismissed without prejudice. Counsel. see those. And you've completed Sonia Williams. Is Felicia Morrow here?
Your Honor, Felicia Mara here. Good morning, Felicia Mara.
Okay, good morning. Have you do you have an attorney, Ms. Morrow?
I thought I would, Elise Boyk, but I'm not sure, if she was still, trying to represent me or if it was just for that day.
Ms. Boyke? Good morning.
Good morning, Your Honor. This is Attorney Boyke. I am appearing on Ms. Morrow's case this morning. I'm just not sure who opposing counsel is today.
Brian Gerten.
Is this for Felicia Morrow?
Yes, it is.
Okay, I will send you a message, Attorney Gerda.
Okay.
Thank you.
Would you all like to go in the breakout room?
We could do that.
Okay, there are no notes. I wonder why it's.
Still, okay. I'll invite you to room 15.
Thank you, Your Honor.
Counsel, you can get back in room 15.
Thank you.
Is anyone here from 11700 Wilshire?
I don't know how to get back to the thing. I don't know how to work iPhone.
And what case are you on? Never mind. Calling case number 233-44810, Open Doors Property Management versus occupants at 11700 Wilshire.
It's a case that Attorney Ted Phillips is working on, I believe.
Okay, thank you.
The Browns are here and they're in a breakout room with Attorney Phillips.
Thanks. Is Tanisha Aikens here? She's still not here. Okay.
I'm here. I don't know why
think
I'm showing up a
she's-
different name.
I think this is her right here under Ace Nay.
Yes, yes, it is. I'm using a different phone today. I'm at work.
I will update her name, Your Honor.
Okay, thank you.
Thank you.
I'm not sure if she has retained an attorney, or if that attorney is joining.
I was in a
today.
breakout room with one and they never reached back out with me.
I did have on Monday, Your Honor, I did have an attorney email me from UCHC regarding this case. But I'm not sure that they are actually providing representation or if they were just trying to advise Ms. Atkins. So I'm hesitant to have a conversation with her without knowing if she's retained counsel.
I understand your hesitation. So,
Your Honor, excuse the interruption. This is Miranda with UCHC. Do you mind if I reach out to that attorney and see whether she's representing in this case and we can recall?
absolutely. Who is that attorney?
It looks like it was Attorney Karigian.
Okay. Yeah, just let me know.
Will do. Thank you, Your Honor.
You can shoot a message to Attorney O'Brien, Lee O'Brien. I'm sure she'll be happy to get that information. And then if not, then they can go in a breakout room. So just keep the parties updated. And you can update me as well, but they need to know more than I do. So
Will do. Thank you.
our party's ready on 023 with Water Edge Apartments and Dorian Hardeman.
I believe we are, Your Honor. We're gonna have to go on the record here.
Calling case number 2334-4023, Water Edge Apartments versus Dorian Hardeman.
Thank you, Your Honor. Sarah Reed appearing on behalf of the plaintiff.
Good morning, Your Honor. May it please the court, Vanessa Fluker, P64870 on behalf of the defendant, Mr. Hardeman.
All right, Mr. Hardeman, can you state your name for the record, please?
Dorian Javon Hardeman Sr.
All right, thank you. This is originally a non-payment. It's a complaint for non-payment of rent. Is there still currently a balance owed at this property?
Yes, there is, Your Honor.
Always.
And what is that balance?
Your Honor, our records reflect a balance owing exclusive of court costs of $25,909.40.
Right. And are you contesting that balance, Attorney Fluker?
Yes, I am, Your Honor, and I'm sure in your file you have my extensive answer. Department of Defense's pleadings, things of that nature. This is a case where SARA funding was involved. And when we were here last time, we wanted to verify whether in fact there was a duplicate payment or error on the part of the management, and there was an error on the part of the management. What actually happened was that they applied SARA funding twice and applied $20,000 to Mr. Hardeman's credit, and in fact came into court, as my Exhibit 1 reflects, and indicated that his full balance was $668.88, including court costs as the balance of his arrears, which he paid along with the next month rent, which reflected in my Exhibit 2. I think it's Exhibit 3. Several months later, they indicated like, oops, there's a mistake. And that is significant because during that time period when they apply, and literally they applied that amount, if you look at Exhibit 8, I attach all the various ledgers as well. You will see where they applied that $10,000 twice at 2 different time periods. So this gentleman is believing that he's current, he's okay, he's paying, and out the booter, like, by the way, you owe us this extra 10 grand. So there is a dispute with respect to the arrearage. And when he attempted to make payments, they're like, no, you need to pay us this extra 10 grand too. Where that wasn't his error. And what makes it more egregious, that type of error, and I'm not saying it was intentional, but negligence is negligence. It's because it was during the window of time that if in fact there was not the full amount paid by those SARA funds and had been reflected in the ledger, Mr. Hardeman may have been able to obtain additional assistance from other sources other than SARA, such as the HERA funds, and by him being a retired veteran as well, through some veteran funds. But all of that was basically precluded because they applied the SARA funding twice, came into court, said, are you owe us $668 or $88 or whatever. He paid that, so here we are with this massive arrears. Yes, he does have an arrearage of the actual rent. I believe it's $13,000 or something. If you add in the current money, maybe $16,000. I'm not disputing that. But what we are disputing is that additional 10K. And our whole position has been, we're not saying we don't owe anything, but we don't owe that extra 10K. And because of their error, they placed him in this position. We would like that $10,000 to be removed from his balance and for him to be able to pay his actual arrearage and give him 30 days to do so. And it's not like he has not attempted to try to do something in good faith. He tried to say, hey, look, take this $5,000. Can we figure this all out? No, they want all their money at once, including the erroneous 10,000, which if you look at my exhibit, that is 8. 8 is just the telling exhibit. That's the ledger from 11/19/2022 when he made the payment of the balance after the judgment. You will see on that ledger where they applied those CR funds twice. And you will see where the client made the payment for the $668 and his regular rental payments for a total payment of $3,005.23, and he was current. So that is what we are requesting today, an adjustment of that amount, and he'd be allowed 30 days to, pay the balance. And if they add in next month's rent, it may be 16,000. But when we were here last time, including me, I think it was April, whatever, it was 13,000 and some change. His rent is 2,000, I think it's 2,325 per month. So that very well could be the case if we add in the current rent. And we're not disputing that, but we're disputing the extra 10,000. And people, well, I'll put it like this: I don't have an extra 10,000 in my back pocket. And when someone makes a $10,000 error, they should definitely take responsibility for that. And all the exhibits that supports this are in my answer affirmative defenses. And they did reply, demand for reply. And if you recall last time, there was no dispute with respect to the error. The prior attorney said that there was an error and that there may have to be some adjustments made accordingly. And I just wanted to verify that it wasn't an overpayment from Metro, Wayne Metro, that they took back rather than a error on the part of management. It was solely an error on the part of management where they applied $10,000 twice. Came into court, represented that information, entered a judgment representing that information, accepted his payment representing that information, and put it on a ledger representing that information, which is attached as my exhibit 8. Thank you.
Thank you, counsel.
Your Honor, my client's position is, number one, if Mr. Hardiman wants to state under oath that he honestly believed that he received $22,000 from Sierra versus the $10,800 that his Sierra letter stated, I would like him to state that under oath that he believed that that $10,000 that was additionally applied to his account in error, he believed that that was his money. Our client's position is, yes, there was a clerical error on Water's Edge part, and it was corrected post-judgment, unfortunately, but that Mr. Hardiman is guilty of some type of fraud by misrepresentation by accepting those funds when he knew they were not his. Secondly, Your Honor, the balance that is due with the 20, if Mr. Hardiman, for sake of argument, believe that that $20,000 was his, he would be, no payments have been made since November. So if he's been attempting to make payments but has been unable to do so, he should have the $13,000 or $14,000 that would be due according to Ms. Fluker. He should have that available immediately. But our position is, we would like to file a motion to have that previous judgment set aside. So I don't know that we're in a position to do a hearing today based on 2612 mistake or clerical error based on that payment being erroneously applied twice.
Your Honor, if I may briefly respond. First of all, I want to respond with regards to the inference or implication that somehow CR funds go directly to the tenant, and they do not. And I'd like to further clarify that it is the landlord that puts in the amount that's in arrears, not the tenant. So Mr. Hardiman would have no way of knowing how much in arrears the landlord will be putting in. But what he would know is that, yes, he got an approval letter for $10,000. He didn't know if any additional money was provided, but what he did know, it was a judgment entered into this court that said he owed $668 and some change, Exhibit 1. He did know that he was advised by management he needed to pay that $688, which was $500 and something plus attorney fees, which he paid. It is reflected in their own ledger attached as Exhibit 8 that amount was paid along with his rent, and he was current. And what I can't agree with counsel is that it was post-judgment and months later when someone realized the error and revived $10,000. So to say or even make any type of innuendo or inference that Mr. Hardiman somehow engaged in fraud because they misapplied payments is erroneous, and I do take issue with that because my client has no control over the application of the CR funds or the amount requested by the landlord. And if she wants to do a motion, I think that should be done. In fact, I think we both should do motion.
But that's on a separate matter. That's on a separate case. So it wouldn't be before me because I don't know who heard that first eviction. However, for this case, 20,000. All right, please mute your devices. So was 10,000? Was there a CR award letter that said Dorian Hardiman was entitled to $20,000?
No, there was a award letter of $10,000, and that was an email was sent to him for $10,000. Then when there was a court hearing, the representatives for management represented that the whole arrears was paid. They put on the ledger that the whole arrears was paid. If you look at Exhibit 8 on my answer affirmative defenses, you see right on there. It's not like it's a $20,000 payment. It's two $10,000 payments, which is not unusual for CR to make separate payments and supplemental payments and things of that nature.
So Attorney Kluger, so 10K was paid, and really 20K was actually owed. It was over. It was about 20K that was owed. 20,600 that was owed, and really 10,600. Well, 10,000 was paid, and then the balance, which was purported to be about $700, was then paid. But you're saying that was an error by the management, and they should have been asking for $10,700 or something.
Exactly. Instead of representing to the client and to the court, I don't know. This court has had an opportunity to do these CR cases if you were on the bench, but it is the landlords who get certain amounts of money from CR. They could say our arrears is 30 grand. CR may say, okay, we're paying X amount or X amount. Yeah, and yeah.
All right, so we're here today. If what was truly awarded is accounted for, and we're talking about the 10K award, not based on the credit, not based on what the court represented, well, what counsel's office represented at the last hearing, which seems to be an error. Where are we at in the amount of rent owed?
According to them, it's $20-something thousand. We're saying it should be less than $10,000 because that was not corrected until months later. We're dealing with a time period where there were program funds available. If they had come into court and said, hey, Sarah only gave us $10,000 for this section, the client would have had an opportunity to either obtain additional CR funds or to go to the HERA program or the Veterans program to get the additional amount. They waited so many months. All that programming was closed, so there's no place else to go to. And he's holding 10K.
I understand that. And there should have been an internal ledger. I'm not saying that I'm ruling on this right now where he's going to be wholly responsible, but there should have been some internal ledger that you know, 10K is a sizable amount. So.
And their internal ledger says the extra 10K was paid. That's the problem. He has a copy of the ledger.
Mr. Hardeman's internal ledger should have told him, hey, you know, 10K is paid. This 10K wasn't paid. So what
Not
you all
if he
should
did it
really
from
disagree.
Sarah.
We should be off $10,000, but the amount should be the same. So if our veteran, have you sought some assistance from the Veteran Assistance Program, Mr. Hardeman?
No, I was just trying to wait to see the outcome of this court and what my actual balance is, but I have seeked a few other funds, but I'm also working.
Okay, well, we're gonna enter a judgment today. I'm gonna enter a judgment today with the actual balance. And I'm probably gonna grant more time so that you may get the ball rolling on assistance. That's what I wanna do today, because what's owed is what's owed, and I understand.
Well, I just want to make a record, Your Honor, because this is really important. This is what I think people are not understanding. You have a specific window of time in which to get these funds. If in fact they had not made this error in November or October, he would have been able to take advantage of the subsequent program from Sarah, which was the HERA program, which also had a veterans component. They could have picked up that tab. Now he has to go around and scramble other places to try to find an extra 10K, which he would not have to have scrambled because it would have been within that program period before it closed. And it was not his fault. And he would have, this is what I want to put on the record, he would have not had any way of knowing. Yeah, he knows what the balance would have been, but he doesn't know what Sarah provides to the landlord until the landlord tells him that, and their ledger tells him twice they applied 2,000 some change. So he would not have any way of knowing that.
And the award letter would have been an indication, but I'm willing to grant the defendant more time, but what is the total balance owed right now?
Your Honor, the balance exclusive of court costs is $25,909.40. I've got statutory court costs of $161.50 for a total due of $26,070.90.
All right, so Attorney Fluke, and that's not including June, correct?
That's correct, Your Honor.
And how many months of rent? What's the late fee?
The late fees going back to, let's see. Starting in November through May, the late fees total $930 even.
Okay, Attorney Fluker, do you have 16,000 as your balance, like 16,070?
With the late fee, I mean, with the attorney fees, I do.
Okay. All right. So, and I know you're asking for 30 days. Is plaintiff willing, well, this is a non-payment of rent, so yes, you will
Well,
be
that
willing
was
to.
up to 16,000. If he has to come up with an extra 10K and try to get all his extra program and stuff, well, it takes time to try to find that and process that stuff. That's a whole nother program, completely.
All right, now, Mr. Hardeman, are you able to pay anything in the meantime? Can you escrow, can a month's rent be escrowed and we check the progress on this? And if no progress has been made, Attorney Fluker, then I move forward. If progress has been made, plaintiff gets a month's rent in the meantime, and we're sort of in the same spot we're at, and they haven't lost their position in the case, you haven't lost your position.
That sounds good to me.
Attorney Reed?
That would be fine, Your Honor. I would assume, it sounds like that he should be able to, are you just suggesting 1 month's rent into escrow? Because it sounds like he was able to make all the payments all along, but for this extra 10,000.
I think it's uncontested that that 16 is old, so I'm not going to discourage anything. And obviously, the more that's paid, the more good faith is shown and demonstrated. But if parties are amenable to that, then you can try to seek some assistance, and maybe you can get the ball rolling, and maybe $5,000 gets chopped off of this before the next time we're back in court. I don't know, but it's possible, and that's a shot.
Okay,
man.
just so I clear, Your Honor, so I can advise my client. You want him to bring the 1 month escrow down to the court and then pay the plaintiff directly for June's rent, or to bring the 1 month escrow to court and pay the June's rent into the court?
It's up to you, Attorney Fluker. I'd rather it go to the landlord or the attorney.
Okay, so pay the escrow amount, which would be a month's rent, and the June's rent to the landlord.
Yes. So the escrow amount will be pretty much half a month minus a day. It's like 7, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. So it's 15 days left. We divide 2325 divided by 31 times 15. So that'll be $1,123. Did you all get the same numbers?
Yes, Your Honor. Thank you.
That good Detroit public school education.
Yeah,
All right. Okay, so the court will adjourn this matter for 30 days for the purposes of Mr. Hardiman to seek additional assistance. In the meantime, the court is also ordering Mr. Hardiman for you to pay $1,123. That will be this month's rent. That's a prorated amount for May. And for you to also pay June's rent in full, which is $2,325. That is to be paid. When June rent, that can be paid directly to the landlord, or Attorney Fluker, you can facilitate that with Attorney Palace's office, and I'll leave that to you, but it's to be paid to plaintiff. And
I will just make sure he gets cashier's checks, makes copies. I'll send the copies to Ms. Reed, and I will also provide a copy to the court under something with a heading of notice of payment to plaintiff for escrow and June rent. So the court will have a copy as well.
okay, thank you. And let's come back June 15th.
June 15th, I'm in federal court. Any other day I probably work, but June 15th, I have a federal matter.
June 20th, June 21st, June 21st.
That works great for me.
This will all be in person after June 2nd.
Okay.
So I'm not sure how the flow of the court will go. That's why I'm hesitant to put out the June dates, but I mean, an adjournment for 30 days is inevitably going to be in June. So bear with us, but June 20, did you say June 21st you'll be in court, or June 15th?
June 15th, I'll be in court. 21st is great.
21st works for you, Attorney Reed?
Yes, it's fine. Thank you.
Okay. I'll see you all back June 15th.
What time?
10 a.m.
All right, thank you. I'll look forward to seeing you then.
All right, likewise. Thank you,
Thank you very much.
counselors.
Thank you, Your Honor.
You're welcome.
My apologies, Your Honor. May I speak? This is Felicia Morrow. I'm not in the break room.
Yes, Ms. Morrow?
Yes.
Yes, and we're listening to you. Is Attorney Boyke is your counsel, correct?
Yes.
All right. All right. She'll notify me when your case is ready to be called.
Okay, thank you.
You're welcome. Attorney Deedland and Attorney Stump. I don't know how they jump up. I can't hear you, Attorney Deedland.
Yes, Your Honor, the parties, I've met with Ms. Hawkins and that we are mutually requesting a continuance to June 7th to allow time for the parties to meet and try and resolve.
Okay, all right. Calling case number, recalling 233-44921. This is City of Detroit versus James Reptopoulos and all occupants.
Yes, Your Honor, James Stump, representing Mr. Reptopoulos, 85529. We met with the attorneys for the City of Detroit, Ms. Hawkins, and we are requesting continuance until June 7th to allow time for the parties to meet and try and resolve a dispute.
All right, and are you all in agreement with that, Ms. Attorney Hawkins? All right, you're muted, but.
Oh, sorry. I didn't enter my appearance. Good morning and good morning to your staff. Shakira Hawk is appearing on behalf of the City of Detroit. Yes, that's our understanding.
Okay, June 7th, do you all need late? You want to go afternoon or morning?
Morning.
Morning.
All right, let's do 10 a.m. And if you all are here earlier and I can call it earlier, that's good, but you see the traffic and landlord tenant court. So June 7th, 2023, we'll just check back. Court finds good cause to adjourn this matter. We understand that there are title issues that need to be addressed in circuit court, so the court will hear back from you all June 7th and see where we're at.
Thank you.
Thank you, Your Honor.
You're welcome. Good luck. Thanks for the patience.
Yeah.
All right, Mr. Dealing.
I think I fixed my audio issue. But Attorney Saman and I are ready on our case.
All right. Calling case number 233-45666, Montina INC versus Stephanie Salad.
Yes, good morning, Your Honor. William Simon on behalf of the plaintiff, 80352.
Thank you, Mr. Simon.
Good morning, Your Honor. Benjamin Dietland, P number 85412, on behalf of Ms. Salad, who should be present in the courtroom on telephone.
Ms. Salad, can you press *6 to unmute yourself? All right. Ms. Salad is here based on counsel's representation. Let's see. All right, counselors, were you all able to come up with a resolution on this matter?
Your Honor, I believe we were going to enter a judgment by hearing with a move-out date of June 19th, if that's correct. Plaintiff's counsel can confirm.
That's correct.
All right, June 19th, 2023. All right, this is a termination of tenancy case. This is a complaint to recover possession of property. This will be a hearing by judgment. Is it a judgment hearing because there's an agreement to remove the named parties?
Yes, Your Honor. It's against occupants.
Correct.
Okay. Gonna remove named parties upon mutual consent. All occupants be removed, plaintiff's named party will be removed. All occupants will be entered. Defendants must vacate by June 19th. All occupants must vacate by June 19th, 2023, or a writ may issue. All right. Thank you, Mr. Deepland. Thank you, Mr. Saman. Mr. Attorney Saman, is that your only case today?
Yes, that's my only case. Thanks, Judge.
You're
Attorney
welcome.
Saman, when you submit that, could you just send me a copy so I can pass it on to the defendant? Since she didn't unmute, I just want to make sure she got a copy.
Sure.
Thanks, I appreciate it.
No problem.
All right. Good morning, Ms. Bishop. Thank you, Attorney Deepland.
Good morning.
Good morning. How are you?
Good. How are you, Your Honor?
Doing well.
That's good.
All right. Do you have any matters ready this morning?
Yes, I am ready if Attorney Haddad is still here. I know she's in numerous courtrooms. Maybe she's gone.
This courtroom is thinged out.
Yeah, I'll just hold off till she returns.
Okay. No problem. No problem. Okay, I'm gonna call out some names just to make sure no one's just sitting in the wrong courtroom, just in case. Madam Court Reporter did an excellent job of checking everyone in, but let's see who's here, who hasn't been talked to. All right, Ms. Akins is here, Ms. Morrow's talked, she has counsel. Is Jessica Tolerek here? Jessica Tolerek. Tolerek. These are all occupancy cases. Okay, let's see. Is Ruby Wilson here? Ruby Wilson?
Your Honor, I have Ruby Wilson. I just need a minute to talk to opposing counsel.
Okay. No problem. Thank you. Devon Beavers? Is Devon Beavers here? Kimberly Wilson? Kimberly Wilson. All right. Jonathan Martin.
Yes, Donovan Martin's here, Your Honor.
All right. Thank you, Mr. Martin. All right, now, Mr. Martin, are you represented by an attorney?
Yes, Your Honor. Attorney Fisher, Janetta Fisher.
Okay. All right. I know she said she had to speak to the landlord's attorney, so I'm pretty sure that's what.
Actually, I've already spoke with her. I'm just waiting for her to appear in the courtroom.
Okay.
We do have a resolution. Oh, here she is.
Yeah, she's here. Okay. Is Alexandra Larry here?
How you doing, Judge? Cornelius Brown here. Is I'm in your court still?
How you doing, Mr.
I'm
Brown?
okay, sir.
Did I just call your name?
No, I was wondering, was I still in your courtroom? I don't know.
I remember your case. You have a case, Mr. Brown?
What you say, Your Honor?
You have a case number?
They gave me the low one. I know the old one. The old one was 233-44810.
Okay, yeah, you're with Mr. Narsigian. You have an attorney, don't you?
Yes.
Who's your attorney?
I don't, my daughter did it for us. I don't know his name right offhand.
All right, I'm gonna invite you into the UCHC breakout room. It's the lobby. And they'll match you up, because I do remember you saying you were retained, so they should be able to match you up when you get in there.
Okay.
All right, good luck.
Thank
you.
Your Honor, we're ready.
All right. But are we going Donovan Martin, 957?
Correct.
867?
Yeah, it is Donovan Martin.
Okay, calling case number 2-334-6657. This is Grant and Main LLC versus Donovan Martin.
Good morning, Your Honor. For the record, Ronnie Haddad, P 84927 on behalf of the plaintiff.
Good morning, Your Honor. Janetta Fisher with Michigan Legal Services representing Donovan Martin. Mr. Martin, please state your name for the record.
Donovan Martin.
Thank you, Mr. Martin. Good morning, Mr. Dad.
Yes, Your Honor. The parties have agreed to enter into a conditional dismissal with 4B checked and a pay or vacate date of June 17th. The total balance due and owing is $705, Your Honor.
All right, this matter will be dismissed in the event $705 is paid before June 17th. This matter will be dismissed. In the event that it is not paid by June 17th, 4B is checked on the conditional dismissal, which means that once an affidavit saying that there was non-payment, a judgment and a writ of eviction can be filed at the same time. You understand that, Mr. Martin?
Yes, Your Honor.
Okay. And do you give permission to your attorney, Ms. Fisher, to sign your name on the document?
Yes, Your Honor.
Okay. Do you have any questions?
No, Your Honor.
All right. The court is satisfied. Anything additional, counselors?
No, Judge.
No, Your Honor.
All right.
I do have two recalls for adjournments, if the court wouldn't mind.
Okay. Good call. Good luck, Mr. Martin.
Thank you.
You're welcome.
The first one ends in 6665, Mr. Lewis, Corey Lewis.
On case number 2-334-6665. This is Grant and Main LLC versus Corey Lewis.
Good morning, Your Honor. For the record, Ronnie Haddad, P 84927 on behalf of the plaintiff.
Good morning.
I'm here.
Mr. Lewis, can you state your name?
Corey Lewis.
Thank you.
Your Honor, I had an opportunity to speak with Mr. Lewis. There seems to be a contention regarding the balance owed. He is going to send me some receipts. If we need to do a ledger adjustment, we're going to do a ledger adjustment. So we're asking for an adjournment for next Friday, if that's possible, the 26th. I believe that's the 26th.
We do, Judge. All right, we can do May 26th at 10 a.m.
10 a.m. Perfect. Thank you, Judge.
Thank you, sir.
Very well.
And then the other one ends in 6654 with Attorney Phillips.
That's it for me.
That's it for you. You are free to leave. We'll be back. You'll be back May 26th at 10 a.m.
Thank you, sir. Thank you.
You're welcome. Is this Ruby Wilson?
Yes.
Yes, Your Honor.
Calling case number 2-334-6654, Argo Property Management versus Ruby Wilson and all occupants.
Good morning, Your Honor. For the record, Ronnie Haddad, P 84927 on behalf of the plaintiff.
One, Your Honor, Ted Phillips, P 35900 for the defendant who is present. Ms. Wilson, could you state your name?
Ruby Wilson.
Your Honor, the defendant needs an adjournment of 1 week. I understand plaintiff is agreeable with that. We just need to get to ledger. There's some dispute as to the amount owed. I would like to get a copy of the file if the court is able to set it aside, and we could pick that up as well.
We will flag the file for you, Attorney Phillips. Okay. What was the previous date that you had, Mr. Dad?
5/24, I believe.
Does that work for you, Attorney Phillips?
That's fine, Your Honor.
Okay. Let's go May 24th, 2023 at 10 a.m. All right.
So Wilson, you're all set. You can leave.
All right, thank you. You have a blessed day.
Good morning, Ms. Wilson, and you have a blessed day. Well,
Thank you.
you're welcome.
Right now, how do you get out of this thing here?
All right. Is Devon Beavers here? Devon Beavers. All right, Mr. Juan?
Yes, Your Honor, we are ready on 5645.
5645, calling case number 2334-5645, Elam Properties versus Tanisha Akins and all occupants.
Amberly O'Brien on behalf of Elam Properties, and my client is here on the Zoom as well.
Suzanne Stepich, Lawan, P48702, Michigan Legal Services, on behalf of the defendant, Tanisha Akins. And Ms. Akins is also in the courtroom. Ms. Akins, will you unmute and state your name for the record, please?
Yes, Tanisha Akins.
All right, good morning to everyone.
Good morning.
All right, this is summons and complaint for a termination of tenancy that was filed late March. Were parties able to work something out?
Yes, Your Honor, we have agreed to a consent judgment with a move-out date of June 10th.
Go ahead, parties agree. Great. All right, Ms. Atkins.
Yes.
Agreeing to a move-out date of June 10th?
Yes, sir.
Is this a consent judgment or a conditional dismissal?
Consent judgment. Consent
Okay.
judgment.
All right. And Ms. Atkins, do you give Ms. Lawan permission to sign your name?
Yes, sir.
All right. Any other questions?
No, I do not.
Okay. All right. So there's the judgment. A writ can be filed after June 10th in the event.
What's your daughter's name? Right, I'm aware.
Okay. All right. Well, good luck. And
Thank you.
according to judgment, Ms. O'Brien, Lee O'Brien, please send one in and we'll sign it.
I will prepare it, Your Honor, and I will send it to everyone.
Okay, that's fine.
Thank
Thank
you.
you all.
Thank you for that,
Thank you.
Attorney Lewand.
You're welcome. And Ms. Akins, you're free to go.
Thank you. You all have a good day.
You too.
Thank
Bye.
you, too.
All right. Take care. Take care, Mr. Eden.
Thank you. You too.
Mr. Santiago, good morning.
Good morning again, Judge. Mr. Vajani and I are working towards a resolution and we're asking the court for a 2-week adjournment. It's 647.
Calling case number 233456447. This is mutual property versus Danielle McCurry.
Sorry, Your Honor. Ely Bajani, P 74626 for the plaintiff.
Good morning, Your Honor. Robert Santiago, Michigan Legal Services, P 57157 on behalf of the tenant, Miss Danielle McCurry, who is present. Miss McCurry, could you please state your name for the record?
Danielle McCurry.
Thank you, Ms. McCurry. I'm gonna put your device on mute briefly, okay?
Okay.
All right, Mr. Santiago, Mr. Bajani, you all needed a brief adjournment.
Yes, Judge.
All right. Would you all like to go beyond June 5th or before June 5th?
Before June 5th, Judge, if the court can accommodate it.
Preferably to keep it in May, Your Honor, if possible.
May 31st.
That works.
All right, May 31st at 10 a.m.
You say 10 a.m., Judge?
Yes, that 10 a.m. If you all are here earlier, we'll call it.
Sounds good. Thank you, Judge.
Thank you, Your Honor.
Thanks, Ely.
Thank you. We'll be in touch.
Sounds good. Thanks, Ms. McCurry. I will be in touch with you also.
Judge, I have a dismissal just to get off your back.
Is this the 5900?
Correct, Your Honor.
Calling case number 22395900, Mutual Property Management versus Leslie Smith.
Good morning, Judge. Ely Bajani, P 74626 on behalf of the plaintiff. I'm not sure if anyone is standing in for Mr. Featherson. He did tell me that he wasn't going to appear today. However, we're still asking just for to dismiss this case without prejudice.
And Your Honor, Mr. Featherson did ask us to make sure that it was dismissed. If you need an appearance, I can make it on his behalf.
Why not?
Suzanne Stepich, Luan P 48702, Michigan Legal Services, standing in for Attorney Featherson.
All right, and this matter is dismissed without prejudice. Thank you, counselors.
Thank you, Your Honor.
Thank you.
Are you done in my courtroom, Mr. Bajani?
I believe so. Have a great rest of the day.
All right. All right. See what else we have. Are we ready on? What do we do with the occupants on Wilshire? Case number ending in 4810.
Your Honor, Mr. Narsigian is in a in-person hearing at the court, and Judge Brew, he said, I've not heard back from him. We have an offer on the table, but he was not willing to agree to an adjournment, but he doesn't have an answer back either. The parties are in a breakout room right now. We're just waiting to hear.
Okay, all right.
If we do not have an agreement, we are going to be asking for an adjournment for them to pursue their probate case that they were not able to do independently, and we now have an attorney to work with them to do that, just to get it all on the table.
Okay. All right, thank you for the update.
Thank you.
Is Zachary Chewy or anyone here for Attorney Chewy? Anyone here from Somerset, 9429 Somerset? Anyone at 18632 Pembroke? Is Rashida Snodgrass here? Is David Stewart here? David Stewart and Rashida, they're both, oh, they may be stuck. They're stuck this entire time. Time to call it.
Your Honor, my name is Rico Martin. I've been waiting for about an hour and something.
What case are you on, Mr. Martin?
Case number 2334665.
Okay, I see. Yep, I have you checked in with Attorney Callahan. Ms. Haddad is doing Attorney Callahan's case today. Do you have an attorney?
No, sir.
You want to speak to Attorney Callahan? Do you want to speak to the landlord's attorney?
I can see him, Your Honor. If he wants.
Okay. I'm gonna invite you into a breakout room. And Attorney Phillips, he's in room 1.
Thank you.
Go. All right, where are the parties out for? Is Ms. Snodgrass and Mr. Stewart here? Have you all made it out? Were you all
Yes.
stuck in the breakout room?
Yeah, we were stuck in the breakout room.
I realized that when you all don't have breakout privileges, so I apologize. But
It's okay.
we are ready to call your case anyway. So are you all ready?
Yes, I'm ready.
All right. I still need to get her out. All right, now she's stuck. All right, give it a second.
No problem, sir.
Okay. DeShante Gray, are you? Oh, okay. Sorry. Hope you're not still here. All right, let's start discussing some of these cases. Is anyone here for Mr. Sikarsky? Odie Murrow for the property at 15914 DeCosta? One 5914 DeCosta. Calling case number 23346693. This is Ryan Sikarsky versus all occupants at 15914 DeCosta. This is O.D. Moreau, who's listed as the attorney on this case. This is a case, the complaint to recover possession of property. Defendant and plaintiff failed to appear. This matter is dismissed without prejudice. It can be refiled or a motion can be filed to reinstate it. That's case number ending in 693. 6693. We're just gonna take a brief break. Madam Court Reporter, let's take a, let's come back at 11:40.
Okay.
All right.
Thanks.
Mr. Dan, we'll be back on the record at 11:40. So, if you want to talk to some more people, feel free.
Will do. Thank you, Judge.
Well, All right, everyone, we are back on the record. Finish up the morning docket. Mr. Narsigian,
Good morning, Judge.
good morning. I know Attorney Phillips was here. Were you all able to work out a resolution, or is there?
No, we're gonna have to go on the record with you, Your Honor.
Okay.
I'm actually standing right outside your courtroom, kind of funny.
Let's go. Are you coming? Are you? Oh,
No, I have an in-person hearing down the hall with Judge Brew, and I'm just kind of walking down the hall and right there. It's just weird. Sorry.
Okay. See if I can see you outside.
Yeah, here.
All right. Well, I am here. So when you finish that, come here, or if there's a delay, you know where.
Yeah, I don't see Attorney Phillips in the court or in the Zoom room, so I guess when he comes back, I'll put my hand up.
He's in a breakout room with some clients right now.
Mm-hmm.
Okay. All right. Not a problem. All right, Mr. Dad, I'm ready for you.
Okay, I guess we can start with a dismissal ending in 6655.
Calling case number 2334665. This is Donian Detroit versus Devon Beavers and all occupants.
Good morning, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff. This is the dismissal without prejudice.
All right. Dismissal without prejudice is granted.
And then I do have a resolution for case ending in 6667.
On case number 2334667, this is Grant and Main LLC versus Shaquante Albritton and all occupants.
Good morning, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff, and the defendant is also present.
Yes, I'm here.
All right, thank you. And can you state your name for the record?
Shaquante Albritton.
Thank you, Ms. Albritton.
Your Honor, I did get a chance to speak with Ms. Albritton in a breakout room. If the court would oblige your judgment by hearing as to all occupants, Ms. Albritton will have until June 6th to pay the balance of $17.86.50. And additionally, she's going to pay her June rent in the amount of $850.
All right, so all occupants must pay $17.86 by what date, counsel?
June 6th.
By June 6th, 2020. And no, and Ms. Albritton, $850 will still be required timely as monthly rent. But
Yep, I know.
it relates to this judgment, $1786.50 must be paid by June 6, 2023, or writ may issue.
Yep.
Okay. All right, Miss, your name was removed and this was entered in as all occupants judgment. So good luck, Ms. Albritton.
Thank you.
Your Honor, the next one is case ending in 6659 with Attorney Phillips.
Calling, let's see. Calling case number 2334665. This is Deferred Management Services versus Rico Martin.
Yes, John.
Good morning, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff.
Morning, Your Honor. Ted Phillips, P 35900 for the defendant. Defendant is present. Mr. Martin, could you just say your name for the record?
Rico Martin.
The parties
All right.
came to an agreement on this one that this would be a conditional dismissal or defendant to vacate by June the 20th. Be dismissal as to defendant against all occupants. It'd be a 4B, conditional dismissal. Is that accurate, Ms. Haddad?
Yes, it is.
All right, and Mr. Martin, your case to be dismissed is this a termination of tenancy?
It's a termination, yes.
Okay, if you vacate by June 20th, 2023.
Yes. Yes,
And
ma'am.
in the event you don't vacate, there could be a judgment and a writ of eviction filed after that date.
Okay.
Okay, so does Mr. Phillips have permission to sign your name on the conditional dismissal form?
Yes, you do, Your Honor.
Okay, all right, you have any questions, Mr. Martin?
No, Your Honor.
Okay, all right, well, you're free to go. Good luck. You'll receive a conditional dismissal in the mail at some point, but June 20th, 2023.
Okay, yes, thank you, Your Honor.
You're welcome. Have a great day.
You too,
Take care,
sir.
Ms. Martin.
Thank you, Counselor. And you're free to go.
Okay, thank you.
Looks like he was needed. This is CD. We have way more files. Cases left. Okay. All right, is Jennifer Moore here? Jennifer Moore. Is the Brown family stuck in room 11 or are they being represented by counsel?
I believe they are being represented by counsel.
Okay, all right,
It's my understanding it's Ted Phillips.
okay. Thank you all. What's going on with Mr. Clark and 689?
I believe Ms. Clark was speaking with opposing counsel directly.
That's Mr. Chu. Oh, I didn't see him check in. Let's see. Mr. Clark or Ms. Clark? It's not Rashida Snodgrass.
Yes, sir.
Okay, I see you've made it out of the breakout room. I'm ready to call your case. Calling case number 2334665. This is Rashida Snodgrass versus David Stewart and all occupants. Can you state your name for the record?
Rashida Snodgrass.
Thank you. And Mr.
David Stewart.
Thank you, Mr. Stewart. This is a complaint to recover possession of property. Ms. Snodgrass, are you
Yes,
the
sir.
owner? Are you the owner of the property at 18632 Pembroke?
Yes, sir.
All right. And Mr. Stewart,
Yes, sir.
do you have plans to vacate the property at 18632 Pembroke?
Yes, I do, sir.
Okay, are you currently occupying that property?
Yes, I am, sir.
Okay, do you all have agreed upon, have you all come up with a resolution or agreed upon time to vacate?
Yes, we have, sir.
Okay, and what date is that? What is the date?
May
You said 10
31st.
days was the minimum, correct?
Correct.
He was wondering if he can add an additional 4 days. Is that possible, Your Honor?
Yeah, it's up to you. Tell him
Okay,
you-
can I ask the question? I told him I would only do it with stipulations because he said he still doesn't have the rent to pay or any of the rent. And then he doesn't want an eviction on his record.
Okay, so I can do a judgment by hearing. That will, instead of, in lieu of a consent judgment where both parties will be required to sign, I can do a judgment by hearing. And in this judgment, if you agree, it's up to you, Ms. Snodgrass. You filed this case, it's up to you. We could remove his name as a named party and put this judgment in all occupants, where all occupants will have to vacate by whatever agreed upon date. Does that work
Can
for
I
you?
ask another question? Will that still show that he'll be responsible for the back rent as well as the damage done to the property?
Well, this is a termination of tenancy case. So you didn't file this to get any rent.
Okay,
Yes.
so this is just to get eviction out. I mean, to get
Yes.
him out of the property.
This is just for possession and, if you all had a lease, that's a contract and that can be, you have an action on that, but this is an action on possession. So if you wanted
14
to go
days
there
then.
and file a lawsuit, that's up to you.
14 days.
14 days, where would that put us?
May 31st.
No, the 27th, right? Is it the 27th?
10 days would put us, 10 days would put us at the 27th.
Okay, so I'll give you the 31st.
I appreciate it.
Okay, so all occupants must vacate by May 31st, or writ can issue any day after. So you will still have to apply for a writ, but June 1st, you would technically be eligible to apply for a writ of eviction
Okay.
for all occupants to vacate. All right, Mr. Stewart.
Yes, sir.
This is a judgment by hearing where all occupants can be removed from the properties if a writ of eviction is filed, and a writ of eviction can be filed June 1st.
Okay.
All right, good luck to both parties. Mr. Snodgrass, I still need you to submit a judgment to the court.
Pardon?
So you can, but we'll need that to sign it, okay?
I couldn't hear you, Your Honor.
I need you to drop off.
I'm
a
sorry, I
judgment
couldn't hear you. Drop off a judgment, okay.
to the court. You can drop it off on 2.
Okay,
All right, good luck.
thank you.
Thank you.
You're welcome. Thank you for your patience.
Have a good day.
All right, you too. Is Jessica Tolerac here? Calling case number 233466637. This is Loss of Merchants Row versus Jessica Tolerac. This is Attorney Katz's case. Nobody has appeared on this case. This case was scheduled for 10 a.m. and it's now 11:59. This matter is dismissed without prejudice. Parties may refile. Necessary. A motion to court. Attorney Callahan, do you have any more cases ready?
I think I might have some defaults, Your Honor.
I think you do. Let's see. Is Kimberly Wilson here? Kimberly Wilson. I don't see her in the breakout rooms. Calling case number 2334-6656, Preferred Management Service versus Kimberly Wilson and all occupants.
Good afternoon, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff.
Thank you. Is Kimberly Wilson here? Kimberly Wilson. Let's see. Does anyone reside on Wildemere, 16247 Wildemere?
I'm here, Your Honor.
All right. And what is your name, ma'am?
Kimberly Wilson.
All right. All right, Ms. Wilson. Ms. Haddad is here. Do you have an attorney, Ms. Wilson?
No, Your Honor, I should have some counsel from Section 8, but I see no one is present.
When you
Your
say you
Honor.
should, there's someone.
Michigan Legal Services or UCHC could speak with her.
All right. Okay. I've invited you into a breakout room. Please click accept.
Am I hidden where it says join?
Yes. Yes.
Thank you, Your Honor.
You're welcome. I'll call some more names shortly, Mr. Dad. All right. Kimberly Wilson is here. Is Alexandra Larry here? Alexandra Larry. Calling case number 2334-6658, Grant and Main LLC versus Alexandra Larry and occupants on Glen Court.
Good afternoon, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff.
Good afternoon. I'm not hearing a response from anyone who lives at 120 Glen Court, apartment A1. Is Alexandra Laurie here? Defendant failed to appear. Counsel.
Your Honor, we move for default judgment for possession. The balance due and owing is $1,685.80 in arrears, not include attorney fees and costs of $160. So the total balance due and owing is $1,845.80.
All right, that amount must be paid on or before May 30th. Or written may issue. That includes 658. What, Judge? All right, let's see. You have some 652. Does anyone live on Waltham Street? 19946 Waltham. Calling case number 2334-6652. Clayton Seymour versus all occupants on Waltham Street.
Good afternoon, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff.
Thank you. Defendant has failed to appear. Counsel, do you have a request from the court?
Yes, Your Honor. This is a termination of tenancy. We move for default judgment for possession.
Default judgment is granted. What is the total amount owed?
It's a termination, Your Honor.
It's a total termination. All right. Defendant must vacate by May 30th, 2023.
Thank you.
652. Does anyone reside at 16709 Trinity? On case number 2334-6653. This is People's Community of Michigan, AFC-H versus all occupants at 16709 Trinity.
Good afternoon, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff.
Thank you, Ms. Haddad. Defendant failed to appear. Counsel, are you requesting a default judgment?
Yes, Your Honor, this is a termination of tenancy, and to our knowledge, the property is still occupied. We are moving for a default judgment for possession.
Default judgment is granted. This is a termination. Defendants must vacate by May 30th, 2023, or a writ of eviction can issue after that date. 653. Is Jennifer Moore here? Jennifer Moore. All right, I don't see her in the breakout room. Calling case number 2334-6660. This is Preferred Management Services versus Jennifer Moore and all occupants.
Good afternoon, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff. This is a subsequent hearing on a termination of tenancy.
All right. Does anyone live at 19461 Stansberry? Our defendant failed to appear. Counsel.
Your Honor, we move for default judgment for possession. To our knowledge, the property is still occupied.
Our default judgment is granted. Defendants must vacate by May 30th, or a writ of eviction may issue. Six, 660. Is Ditanja McCreary here? Ditanja? Does anyone live on St. Aubin? Calling case number 2334-6661. This is Preferred Management Service versus Ditanja McCreary and all occupants.
Good afternoon, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff. This is a subsequent hearing on a termination of tenancy.
All right. Is there anyone else in St. Albans in this courtroom, present in this courtroom? Sterling Watson. I don't know who that is. All right. Default judgment. Are you requesting a default judgment, counsel?
Yes, Your Honor.
All right, default judgment is granted. Defendants must vacate by May 30th, 2023, or a writ of eviction can issue. All right, is Robert Hale here? Robert Hale. Calling case number 2334-6662, Grant and Main LLC versus Robert Hale and occupants at 120 Glen Court, Unit 405.
Good afternoon, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff. This is a subsequent hearing on a non-payment of rent.
All right, and defendant isn't present. How much rent is?
So your honor, that's the thing. I would request, I know he's not here, but I would request an adjournment for Monday because looking at the ledger here, the balance is zero, but only because he made a payment yesterday. His payment that was made on 5/6 was, I'm sorry, on 5/12 was reversed on 5/16. So he made another payment in the amount of $794.50, which is the balance owed. And I suspect that this is it's just a game, just so that the balance could be zero during court. And then I just don't want to take the chance of it bouncing again or reversing. So I'd prefer to just adjourn it to Monday for the payment to clear. At which point, if it does clear, then we'll dismiss it on Monday.
All right, we can come back May 22nd. I don't know if that's enough time for notice.
If you'd like to give, to allow for time for notice, your honor, that's fine as well.
Let's do May 31st.
That works.
9 a.m.
That works, your honor. Thank you.
Is Philip Kennard here? Philip Kennard, calling case number 2334-6663, Grant and Main LLC versus Philip Kennard and occupants at 12088 Stokel, Unit 3.
Good afternoon, your honor. For the record, Rania Haddad, P84927 on behalf of the plaintiff. This is the subsequent hearing on a non-payment of rent.
All right, counsel, how much rent is owed?
The balance due and owing is $2,168.94.
All right. Defendants failed to appear. Are you requesting a default judgment?
Yes, your honor. We're requesting a default judgment for possession only.
All right. For possession only, did you not have personal service?
No.
Okay. All right. I will note that a money judgment was filed, but there is no personal service. Default judgment is granted for possession only in the amount of $2,168.94, which must be paid by May 30th, 2023, or a writ of eviction may issue. Is J. Lawrence Gary here? J. Lawrence. Is J. Lawrence here? Calling case number 2334-6664, Grant and Main LLC versus J. Lawrence Gary.
Good afternoon, your honor. For the record, Rania Haddad, P84927 on behalf of the plaintiff. This is subsequent hearing on a non-payment of rent.
Thank you. J. Lawrence Gary. Anybody on Rockdale? 13934 Rockdale. Defendant failed to appear not once but twice. Counsel, are you requesting a default judgment?
I am, your honor.
All right, what is the amount due at this time?
My apologies, your honor. The balance due and owing is $525.50. Most recent payment was made on 5/12. I'm not really sure why the tenant defendant is not here, but I mean, I hate to do this, but I am requesting a default judgment.
Okay, $525 though, and 50 cents.
Correct, your honor.
Okay, and that default judgment is granted, and that amount is to be paid by May 30th, 2023, or a writ of eviction may issue.
Thank you, Judge.
You're welcome. Judge, this is a default judgment? All right. Mr. Brown.
Yeah, I think we're ready with that one, Your Honor.
1-2-3-3-4-4-8-1-0. This is Open Doors Property Management versus all occupants and the Brown family.
Sean Norsegian, P77410 on behalf of plaintiff.
Morning, afternoon, Your Honor. Ted Phillips, P35900 on behalf of the occupants of Brown family. Could each of the members occupants please state their name?
Roger L. Brown. Cornelius Brown.
Okay. Your Honor, the party's been trying to come to a resolution on this. We just picked this up today, essentially, and we've not been able to come to a resolution. This is a family home of 40 years where the grandmother passed, and they're trying to do a probate case. There's some concerns about the tax auction and the lack of notice that they've indicated was an issue, one issue. Miss Anderson, who's a member of the Brown family, but not an occupant of the property, has been trying to get the probate case filed. As recently as yesterday, documents came back from probate indicating that there was some sort of defect. We now have an attorney that can take the probate matter and get it filed properly. We would ask for an adjournment of 1 month to have that done. As a showing of good faith, we would not object to a reasonable escrow. This is a house that has a number of repair issues to it, and I would say that a reasonable escrow would be around $500. There is a veteran, a disabled veteran who's been there. The house has been in the family for 40 years, and I would ask for the opportunity for them to take every step possible to save their home. And we'll continue to try to work with the plaintiff to see if there's any kind of a resolution that might be arrived at. So far, that's reached dead ends.
All right. Counsel.
Here's my problem with that, Judge. Last time, the last hearing that we had 3 weeks ago or so, whoever the legal aid office was that was handling that day's docket did not represent the Browns. I spoke with the Browns. I told them that I would agree to the adjournment to today, and if they proceeded with whatever circuit or probate cases they think they need to file to assert whatever claims they have against the county. That being said, they haven't done anything. They're asking for another month. On top of that, this eviction, so this property was lost at tax auction. It was sold last September. We actually filed an earlier eviction against all occupants, which we had to dismiss because my client sent the notice to quit 3 days before they received the deed from the county. So the Brown family, and I will say that the Brown family, they were very nice. I spoke with all of them, and I feel bad taking a strong stance here, but they've been on notice since October that they've lost the property. Here we are 7 months later. Nothing has happened. There's been zero movement whatsoever. And now all of a sudden UCHC says, okay, we're going to represent them and we need another month. That's not at all fair to the true owner of the property who paid for the property at the tax auction, took all the proper steps. When they made a mistake, they corrected it, dismissed the previous case and filed this new one. And we're sitting here on the hook waiting while they figure out whether or not they even have a claim. So if your honor is inclined to grant an adjournment, then $500 escrow is nowhere near enough. I don't care what the condition of the house is. Good luck finding anything to rent for $500 a month. I thought I was going to be reasonable and ask for $900 a month. Not one of my eviction cases with houses in Detroit have a rent of less than $900 a month. They all seem to be between $950 and $1,300, and then above for special cases.
But at the same time, bro, y'all don't live in Detroit neither.
Please.
You don't live in Detroit, so how you just gonna say
Brown,
what's
Brown,
noticed in
do not,
Detroit?
Mr. Brown, do not cut off Mr. Narsegian.
You know, Mr. Brown, you know where Mr. Narsegian lives.
I mean, I don't know where you live, but what I'm saying, Your Honor, it's like unfair, you know what I mean?
He was
It's
saying,
like unfair.
he's saying that
It's unfair, man.
he represents a lot of landlords, and the pricing of rent for the cases that he deals with isn't at 500, it's around 900 to 1,300. That's all he's saying.
Yeah, I understand that, Your Honor, but it's been a frustrating. It's been frustrating.
I understand.
So that's essentially it, Your Honor. They've had plenty of chances to do this. Again, I feel bad in asking for a judgment at this point, but nothing has been done. My client's been prejudiced. And like I said, if Your Honor is inclined to grant them another bite at the apple, then we're going to ask for something that's actually reasonable, and that would be $900 a month. Beginning, since there's no lease between the parties, today's May 17th, I would give them, a week to pay that by the 24th, and then another $900 a month on every 24th of the month until this matter is resolved. And if they get possession of the property, they can have their escrow money back.
Your Honor, a brief response.
Sure.
Your Honor, what I would take issue with is that they've done nothing. I mean, Ms. Anderson outlined a number of things that they have tried to do with the probate court. It's a very frustrating court. They're not, as I understand it, in person. Things have to be filed online. I've had a number of clients that we do not do probate. So UCHC is not taking this as a probate case. There are attorneys with Michigan Legal Services that will handle the probate now. We'll have somebody to handle that, so it will get done. But it is very frustrating for attorneys, and it's even more frustrating for non-attorneys to try to maneuver the probate court. So there has been efforts made there, and they now have landed with an attorney that can do that. I would leave to the court the discretion for what is a reasonable escrow. It is there to protect the plaintiff. The plaintiff's not going to be renting this property out anyway, from what I understand. So they would not be getting any rent. I don't think $500 is a ridiculous amount for protection purposes. Whether they could or could not get $900 in the condition it's in, from what I understand of the condition, I doubt that they could, but I would leave the discretion of the court, obviously, what a reasonable escrow would be. And obviously, if escrow was entered, it would be for payment to be made on a monthly basis, as counsel has outlined, until the case is resolved. So, but that payment cannot be made until there's an order entered with the court, so that because the clerks will not accept escrow without an order. So I would just on the payment within 7 days, I would say payment upon 7 days of the entry of the order, so that it's clear that we have the actual ability to do it. If we get an order on the 25th, we can't have paid it. They can't have paid it by the 24th.
All right. Going to order. We're on the 17th of the month. So a probate case was filed. What was filed? A petition for what?
They attempted to file, and the paperwork was sent back to them yesterday. So they will get with the probate attorney, hopefully no later than tomorrow. And we will then that attorney will then proceed to get the necessary documents. I've not done probate, Your Honor, so I'm pardon my ignorance, but that will be on another attorney, but they will take care of it.
I just don't understand I'm going to grant a brief adjournment and order $400 a month, $400 for this month and $800 for any forthcoming months. So $400 for the rest of this month, and then $800 on June 1st and following months. I don't expect this case to go on for months, but in the event it does, it will be at a rate of $800 a month. We'll be back in person. Let's see, June June 21st. We can come back June 21st.
Yeah, what day of the week is that? I don't have a calendar handy. I'm sorry.
Wednesday.
Wednesday.
That's fine.
Wednesday at 10 a.m. And if you can get that order to me so I can sign it and get it to the.
No problem, Judge. I'll have it filed today.
Okay, and to the
Mr.
Brown
Narsigin,
family.
just send me a copy, please.
No problem.
I don't know what the legal argument is, but it seems to be that you all are in the 25th hour. So whatever you have to do, exhaust it, because it's only so long I can keep a case open without a true legal argument, to be honest.
Understood. The Brown family, we're gonna go back into a breakout room, okay?
Thank you. Thank you, Your Honor. Thank you, Mr. Narsigin.
You're welcome. Thank you. You guys take care.
Thank you.
I'll take. Sterling Watson.
Yes.
Mr. Watson.
How you doing?
Doing well. I saw you logged in. Are you looking for your case? Are you trying to find out what you're supposed to be?
Nope. I'm trying to figure out what I'm supposed to do. I had you yesterday, and the lawyer on the case never sent over the paper he was supposed to send.
Okay. Give us a second, and we'll try to figure out what happened in your case. Let's see.
Okay.
I see you put a chat in, so I'll check that chat.
Okay. Yep. I put the case number in the chat.
Okay, I see you put the case number in the chat. Once my clerk can check it, give him about 5 minutes, and then we'll follow up.
Okay. I'm gonna go back.
We only have two or three more cases. We only have 3
Okay.
cases.
I'm gonna go back on mute.
Okay. All right. Thank you. And Attorney Luan?
Yes, Your Honor, we are ready on 6656.
Sorry, we have 4 cases left. Calling case number 2334-6656, Preferred Management Service versus Kimberly Wilson.
Yes, Your Honor.
Good afternoon, Your Honor. For the record, Rania Haddad, P84927 on behalf of the plaintiff.
Suzanne Stepich Lawan, P48702, Michigan Legal Services, on behalf of the defendant Kimberly Wilson, who is present in the courtroom. Ms. Wilson, will you state your name for the record, please?
Good afternoon, Judge. My name is Kimberly Wilson.
Good afternoon.
And we have agreed to a conditional dismissal in this matter. Move out date of June 16th. And 4B will be checked.
Okay. And Ms. Wilson, do you give Ms. Lawan permission to sign your name?
Yes, Your Honor.
Okay. Do you have any questions?
No, Your Honor.
All right, this is pretty straightforward. This case will be dismissed in the event that you vacate by June 16th. In the event that doesn't occur, plaintiff would have the right to enter a judgment and a writ of eviction at the same time without us coming back to court.
Yes, Your Honor.
Okay, all right. The court is comfortable with this conditional dismissal. Good luck, Ms. Wilson, and have a great day.
Thank you so much. You as well, Judge.
Thank you, Your Honor.
Thank you, Judge.
And Ms. Wilson, you're free to go.
Okay, thank you so much. Thank you, ladies.
Yep.
Is anybody here on Somerset's 9429 Somerset? Calling case number 2334-6689. This is the estate of George Sarakis versus all occupants at 9429 Somerset. This is Attorney Chewy's case. Linnell and Associates. Defendants have failed to appear. I have reason to believe that there is a notice issue. I'll note in the file possible clerical mix-up with the case number and case heading. But in any case, parties have failed to appear. So this case is dismissed without prejudice. And in the event plaintiff motions to get it reinstated, I doubt the defendant will motion to get it reinstated. But in any event, either party motions to reinstate it for the reasons of clerical error, court will reinstate this case. On the docket, it's mixed up with two parties' names. I'm not sure if it's just a docket sheet or if it's in the computer, but the pleadings look proper. But I don't know. So the case is dismissed without prejudice unless it's refiled or a motion to reinstate. That's case number 233466689.
Judge, you see someone here for that? Clark,
689, huh?
yeah, Clark. It says Clark. I think I signed him in this morning.
Let's see. Mr. Clark, can you press *6? Thank you, Madam Clerk.
Yep.
Is Clark here? All right. I don't. And if anything, it's probably a defendant. So, doubt there's an objection. All right. We have 2 more cases left. 354. Are you ready on yours, Mr. Curtin?
Yes, Your Honor.
Okay. On case number 23346-354 Brentwood versus Felicia Morrow.
Brian Gerda, P807556 for plaintiff.
Lee Boyke, P84955 with Lakeshore Legal Aid on behalf of the defendant Felicia Morrow, who is in the courtroom today. Ms. Morrow, do you mind stating your full name for the record, please?
Felicia Nicole Morrow.
And Your Honor, I apologize. My camera is not working this afternoon, so I just wanted to mention that.
No worries.
I believe we've reached an agreement here on these terms. I'm not sure, Attorney Gerda, if you'd prefer to put them on, but I can if you'd like. We have reached an agreement for a condition, basically a substitution and stipulation to get the escrow funds released. And then we will be reaching an agreement in terms of a payment plan for $200 starting, an additional $200 starting monthly as of July 1st, 2023 with 4B marked. And the amount that we are putting on that for the total amount owed is $2,407.04, I believe.
All right.
Go
ahead, Councilman.
The escrow being referred to is from a prior case, different case number of a conditional dismissal that was entered last August, because the balance on Ms. Morrow's account currently is $4,347.04, including the court costs. We understand $1,900 in escrow, thanks to Sarah, sitting with the 36th District Court in that last case. So this plan is that we'll file the appropriate substitution stipulation to have that released to my client.
Okay.
And then that would leave the balance, the 2,000.
Yes.
Sorry, I don't have that exact number that Ms. Boyke said. And
Yeah,
then that would be paid off at $200 a month. 4B checked.
Thank you for that clarification. That's correct, Your Honor.
Okay. Thank you. Thank you both. All right, so it's rent. There's still a rental obligation monthly plus $200.
Correct, Your Honor.
Yes.
And $200 will start in July.
July 1st. Yes.
All right, Ms. Morrow, are you?
Yeah.
Are you in agreement with this conditional dismissal?
Yes, I am, Your Honor.
Your attorney, I'm sure, has done a good job of informing you. You've heard all of the terms. Do you have any questions?
No, I don't. She was excellent.
All right, you heard that, Attorney Boyke.
Yeah, I'm writing that down. I'm going to quote her on that one.
All right. Okay, well, the court is satisfied. 4B is checked, which means that a conditional dismissal, if you have reached this agreement, a judgment and a writ of eviction can be filed at the same time.
Okay.
All right, so, but if you fulfill this agreement, this case is dismissed. So it's a two-way street, Ms. Morrow, and we wish you luck. Take care.
I thank you very much, Your Honor. Have a good day.
You too.
Thank you. I appreciate it. Thank you.
So I'm just hanging up now, Your Honor.
I didn't hear what you said.
Am I just hanging up now, or do I have to wait for anything?
Ms. Boyke, do you need to talk to her?
I will be giving you a call, Miss Morrow, in the next day or so. You're free to hang up right now.
Okay. Thank you guys very much.
Yep. We'll talk to you soon. Thank you all.
You're welcome. Danielle McCrory. Let's see. Did we take care of this?
Yeah, you adjourned. Next date is 5/31/23 at 10 a.m.
All right. Yeah, yes, we did. 5/31/23. Thank you.
No problem. The only one I see left is Angle Bush.
I think we're done. Do you all have any other cases pending? Which one did you have, Angle Bush?
Bush was a adjournment, and I faxed in, oh, I'm sorry, emailed in, hopefully to the right email address, the stipulation to adjourn.
Okay.
Okay.
I did have one question, Your Honor. There was a case at 901, Wendy Houston, 450. There was a new attorney for the plaintiff, and I didn't catch their name. I'm wondering if that is.
Born Camp. BORNKAMP. I'm almost certain it's KAMP, but write down it's either CAMP or KAMP. And I'm almost certain it's KAMP.
Yeah, I think it was.
So
Better memory than I, Your Honor. I do, now that you say that, I do recall it. Thank you.
No problem.
Have a good day.
I wrote it down.
Oh, well, but better documenter than me. I thought I did too. But, all right, take care.
Okay, you all take care. Thank you, Judge. Do you know what happened with 810 on page 2?
810.
I see again.
Yeah, it was
That's the one we
adjourned.
just had. That's the one we just had. It was adjourned to
Is
the
that the Brown
22nd.
family?
That's the Brown family.
Okay, that was adjourned with the escrow order. Thanks, Attorney Phillips.
Sorry,
All
Your
right.
Honor, one more question if you would entertain me. What happened with Ruby Wilson, defendant Ruby Wilson, case ending in 654?
Ruby Wilson is Attorney Phillips as well. What did we do in that case?
That was adjourned 5/24/23 at 10 a.m.
So I think it was adjourned to May 24th at 10 a.m.
Perfect. Thank you so much.
Well,
Judge, I got one more.
what you got?
689 on page 1.
689.
6, 8.
It was dismissed.
Yeah, I dismissed that case. That had a mix.
Yeah, you were like
689.
clerical error or. Yeah.
693 and 689. 689 had a different attorney than was on pleadings. So they say they missed that date, I reinstated. But I don't know. Maybe it's a dismissal. All right, you all have a good weekend. I'll see you all on Monday. I'm off to go talk to all the other judges. We'll see how that goes.
Good luck with that.
Thank you.
Have a good
I'm
weekend.
here.
Have a good weekend.
Have a
Look
good
forward to. Yeah. All right. You all have a great